Hey, this is case number 18, CR 249, State of Ohio versus Mark Nathaniel Potts. And are you, Mark Nathaniel Potts, appearing there from the jail?
Yes, sir.
All right, this is a hearing on a bond review being conducted by Zoom. Mr. Potts' attorney, Danielle Witt, she's appearing from her office, appearing on behalf of the state, and the prosecutor's office is Prosecutor King, Assistant Prosecutor King. The defendant was arraigned on a charge of failure to register a change of address as a registered sex offender. He did not have counsel when the court set bond, and so pursuant to statute, this court is conducting a review of the bond. Ms. Witt?
Yes, Your Honor. We do ask for a reduction in bond. And just doing a quick search, I did not see any prior charges in this court, and apparently he also has a Hillsborough address.
Mr. King?
State would ask that the current bond remain in place, Your Honor. There's been a warrant out for his arrest in this case since 2018. ODRC's website also shows his status as an APA violator at large, and he does have prior felonies for unlawful sexual conduct with a minor and failure to comply. So based upon that, I do believe the current bond is appropriate. Thank you.
I will also note in the Ohio Court Network report that bail had prepared, there was a warrant for failure to appear issued back in 2017 out of Clinton County. And given the fact this case has been pending for 7.5 years without the defendant being located, the court feels that bond is reasonable to assure his appearance set at $10,000. So bond will remain the same. Thank you.
Thank you.
Case number 25 CR105, State of Ohio versus Quentin M. Binniger. You're Quentin M. Binniger appearing there from the jail?
Yes, sir.
All right, Mr. Binniger is charged with aggravated possession of meth and failure to comply with the order to signal a police officer. This is a final pretrial. I think we have trials set for July 23rd and 24th. Ms. Hapner, did you get your discovery filed?
Your Honor, I believe we have this case worked out. I just need to get out to the jail. Well, I'm sorry. We'll be doing an open plea. We'll be arguing sentencing. I need to get out to the jail this afternoon and get my client's signature.
All right. Okay, well, if you can do that then, and then contact Mrs. Oyer for a date. I believe we may have some time tomorrow or Friday.
That sounds good.
All
Thank
right.
you.
Thank you. All right, Ella McGinn. Or not. Okay. All right. This is case number 26 CR 18, State of Ohio versus Ella M. Gwynn. Are you Ella M. Gwynn appearing there on the screen marked Field of Hope?
Yes.
All right. This is a final pretrial. Ms. McGinn's attorney is Catherine Hapner, appearing from her office, and appearing from the prosecutor's office is Assistant Prosecutor King. As I indicated, the hearing is being conducted by Zoom. I do have a proposed plea form. Ms. Hapner, are you and your client both in agreement that we can conduct this matter by Zoom remotely rather than in-person appearance in the courtroom?
Yes, we are.
You're all right with that, Ms. McGinn?
Yes.
All right, since you're not in the courtroom seated next to your attorney, if at any time during this proceeding you need to talk with her, you just let me know. I'll put the two of you into what's called a breakout room. It'll be just the two of you on the screen talking to each other, and no one else will be able to see you or hear you. Okay?
Okay.
All right. So, Ms. McGinn, you're charged with aggravated possession of methamphetamine, a fifth-degree felony, and I believe we have a trial date of July 23rd. And I have received this plea of guilty form. It's 3 pages long. I'm going to hold the first page up to the camera. Has your name, case number, plea of guilty. Do you recognize that document?
Yes, sir.
On page 3, there's a sentence that reads, I enter this plea voluntarily, and immediately below that, there's a line for signature defendant, and I'm looking at the signature, appears to be Ella McGinn, and is that your signature?
Yes, sir.
Do I pronounce your name correctly? Is it McGinn or McGuinn?
McGuinn.
McGuinn, okay. All right. Now, Ms. McGuinn, when did you sign this plea form?
I think it was day before yesterday.
All right. And when you signed it, did you understand that it's an agreement to plead guilty, meaning there's not going to be a trial, and the next step in your case would be a sentencing?
Yes, sir.
Now, before you signed it, had you spoken with Ms. Hafner, discussed the matter, and so that you knew what would be in this document?
Yes.
And I
had her on the phone day before yesterday.
Okay, when you went over this agreement?
Yes, sir.
Okay. And do you feel you had enough time to fully consider the matter before making this decision?
Yeah.
And did you sign this agreement voluntarily?
Yes.
And are you going forward today to enter the plea pursuant to this agreement voluntarily?
Yes.
All right, now the agreement says on page 1 that you're going to plead guilty to the charge in the indictment of aggravated possession of methamphetamine under section 2925.11 of the Higher Revised Code of fifth-degree felony. Further states that you understand that the maximum penalty for that could be 12 months incarceration, or minimum of 6 months. There could be a fine of up to $2,500. Do you understand that?
Yes, sir.
Now, do you have any other charges pending against you in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
I'm on probation in Pike County, too.
All right, and for a felony?
No, they were on misdemeanors.
Okay. All right. Now, under the law, if you should be convicted, and if you should ever be sentenced to serve a prison term on this offense, the law provides that the adult parole authority may, at their option, place you under what's called post-release control for a period of up to 2 years after you're released. And they would set the conditions, and if during that period of time you failed to comply, they could return you to prison as a sanction to make you serve an additional period of up to half of whatever the prison term was for one or more violations. But if you're convicted of a new felony and sentenced to prison on that new felony, then in addition to whatever sentence the judge in that new case can impose, that judge could also sentence you for committing that new offense while on post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, I'm not required by law to sentence people convicted of this offense to prison. I can't impose what's called community control or probation. So that means that instead of going to prison, you would be put under the supervision of a probation officer on the term set by the court. If during that period of time the probation department felt that you were not complying with those conditions, they would file a written allegation of that with the court and give you a copy. There would be a hearing at which you would be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to a period of incarceration between 6 and 12 months, fine you $2,500. And if you were convicted of a new felony while on community control in this case and sentenced to a term of incarceration, that sentence could be ordered to be served consecutively to the sentence in this case, meaning one after the other. You understand that?
Yes, sir.
All right. Now, the charge in the case alleges that on or about September 9, 2025, in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Higher Revised Code. So that's the charge we're talking about, with the penalties that I described earlier. Do you understand what it is you've been charged with by the state, what they said you did, when, where, and how they alleged that you did it?
I think I kind of do. sure.
Okay, what is it you don't understand?
I didn't understand that, I didn't really have any meth on me. I just had a baggie that had residue in it.
Okay, well, that's meth. That's why it's called, yeah. So the amount, and on this charge, the amount of meth doesn't matter. So if there was a small amount, as long as it tested positive, that's sufficient to constitute the charge.
Okay.
Okay?
Got you.
So what you're saying is you understand that you had a baggie that had at least enough residue to test positive for methamphetamine.
Yeah.
Okay. Am I correct on that, counsel? I spoke before confirming it.
You are.
Yes.
All right. Well, sometimes I let my years of experience override my using the time to make sure I'm correct. All right. Now, are you under the influence of any types of drugs or alcohol?
I just take like psych meds and stuff like that since
All right.
I'm here.
And are any of those medications, do any of them interfere with your ability to understand what it is you read and signed Monday and what's going on here today?
No.
Okay. All right. And has anyone threatened you to make you plead guilty?
No.
And have you discussed the nature of this charge, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yeah.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Now, on page 2, there are a couple of lines printed in bold and underlined that read as follows. Defendant will enter plea of guilty to the indictment. State defense jointly recommend community control and substance abuse treatment. Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Under the law, Ms. McGuinn, the matter of sentence is up to the judge, not the parties. And so even though there's a recommendation from both sides as to what the sentence ought to be, the court's not bound by that. If you plead guilty, the court, after considering all the information submitted at the sentencing, could decide that's not the correct sentence, could sentence you to between 6 and 12 months of incarceration and fine you $2,500. Do you understand that?
Yes, sir.
Now, Ms. McGuinn, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
You have certain constitutional rights, you must understand, before I can accept a guilty plea. First, you have a right to counsel. Ms. Hapner was appointed to represent you since you did not have the funds to hire your own attorney. Now, her appointment wasn't simply to try to work the case out, but to provide whatever defense may be available to you under the law that you would like her to provide. So, if you decide that you do not want to do this, that you would rather defend against the charge, she'll continue to represent you and defend you, including a trial, if that is what you want. You understand that?
Yes, sir.
All right, now, under the law of the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County and that are summoned for jury duty on your trial date. After they are selected, the evidence is presented, and then the judge instructs them on the law. And then that jury of 12 people would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you did want to plead guilty, but you didn't want to have a jury trial, you could waive in writing, which means to give up your right to have a jury trial, in which case you could then have what's called a court or bench trial, meaning that instead of a jury, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the law, you have the right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Now, under the law, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a subpoena, that's a court order, and that requires the people that are named in that subpoena to come into court to testify on your behalf, even though they don't want to be here, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution and laws of this state, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence at any time in these proceedings. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution and the law, you have a presumption of innocence in this matter. What that means is that you're presumed innocent until proven guilty by the state of Ohio on every essential element of defense charged by proof beyond a reasonable doubt. So the burden of proof isn't on you to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at your trial to defend yourself at all. You can, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of defense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yeah.
Now, originally entered plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of a not guilty plea. The guilty plea would admit the allegation in the indictment, admit that it's a crime, that you committed that crime. That plea would waive or give up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception. The plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're the one that's saying you're guilty, so that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, and finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other limited circumstances, an appeal could be filed. It would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
Are you a U.S. citizen, Ms. McGuinn?
Yes.
Right now, do you have any questions about the charge or the possible penalty?
No.
You understand it?
Yeah.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
And you understand that the matter of the recommendation of sentencing is not binding on the court?
Yes.
Do you have any questions about the constitutional rights I've explained to you?
No.
You understand those?
Yes.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
I don't know.
All right. Is there anything you need to speak to Ms. Hapner about before we go any further?
Yes, please.
All right.
Please speak to her.
And now I can't find the tool to put in a breakout room. Ah, here we go. New button that shows 9 icons. I have to find one. All right, there we go. Yep. Wait for Ms. Hapner to come back in.
Okay.
Okay, we're back on record then on State versus Ella McGuinn, 26 CR 18. She's had an opportunity to consult with Ms. Hapner in the breakout room. Are we going to go ahead and proceed then, Ms. Hapner?
Yes, we are.
All right. So you have any other questions about anything, Ms. McGuinn?
No, I'm good.
Then is it your decision to go forward with this plea agreement, enter plea of guilty pursuant to the terms of the agreement we've gone over here?
Yes, sir.
And as to the charge which alleges that on or about September 9, 2025 in Highland County, Ohio, you knowingly obtained, possessed, or used Schedule II controlled substance methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony carrying a possible term of incarceration of 6 to 12 months, fine of $2,500. How do you plead?
Guilty.
All right. The court finds on this day in open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Please accept an order filed. Defendant is found guilty of the charge. The court refers the matter for a pre-sentence report to the probation department. The bond will be continued, and the sentencing hearing will be on August the 5th at 9 a.m. All right. Probation will reach out to you, Ms. McGuinn, for an interview for your pre-sentence report. Anything further from counsel?
No, Your Honor.
All right, thank you. All right, this is case number 26, CR 57, State of Ohio versus Wyatt Corey. Are you, Wyatt Corey, appearing there from the jail? Are you, Wyatt Corey, appearing there from the jail? Okay, you need to speak up because your microphone's a little ways and from you, and I couldn't hear you. Okay. You are Wyatt Corey, right? Gotcha. There, that's better. All right. Mr. Corey is appearing by Zoom from the jail. His attorney, Dennis Kirk, is appearing from his office. Appearing on behalf of the state from the prosecutor's office is Assistant Prosecutor King. Defendant is charged with an 8-count indictment with various aggravated trafficking and possession charges and trafficking in cocaine and a forfeiture. The matter is set for trial July the 20th. I have received a form here, Mr. Corey, that indicates you're going to withdraw your not guilty plea and plead guilty to counts 5 and 7 of the indictment. This is a 2-page form, I believe. And before I go on, Mr. Kirk, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
We are, Your Honor, and also wanted to note, while we do not know who the CI is yet, based on my conversations with my client, it's possible I have previously represented the CI in another matter. I advised my client of that, and he advised he is waiving any conflict that might create and wishes to proceed today.
Okay, thank you. All right. Well, first of all, Mr. Corey, you're okay to proceed today by Zoom rather than being in court?
Yes, sir.
All right. And if during the hearing you need to speak with Mr. Kirk, just let me know. I can put the two of you into a breakout room. It'll be just the two of you on the screen. No one else will be able to see you or hear you, and the deputy will step out of the room during that consultation so that it's private. Okay? Okay. You need to speak up.
Yes, I'm.
All right, thank you. Thank you. Yeah, your microphone's further away than mine is, so I need to make sure that you're picked up for the recording. All right. Now, Mr. Corey, Mr. Kirk just indicated that though the identity of the confidential informant had not been specifically revealed, appears that maybe based on your conversations with him, you have a good idea who it is, and that he had possibly represented that individual on an unrelated matter in the past, and so you're aware of that issue, of that fact? All right. Does that have any problem? Does that cause you any concern about him continuing to represent you and advise you in this matter?
No, Your Honor.
All right. So you're willing to waive any potential conflict that might be under the rules for attorneys and agree to go ahead and go forward?
Yes, Your Honor.
All right. And Mr. Kirk explained that to you so that you're satisfied with your knowledge of what the circumstances are.
Yes, Your Honor.
All right. Thank you. All right. So I have this agreement here, Mr. Corey. I'm going to hold it up to the screen. It has on the first page, hold it up to the camera, I should say, and it has plea of guilty, your case number, your name, and it says you're pleading guilty to counts 5 and 7. So I'm going to hold it up to the camera. Do you recognize that document there, Mr. Corey?
Yes, sir. Yes, sir.
All right. On page 3, there's a sentence that reads, I enter this plea voluntarily. And then below that, there's a line for signature of defendant. And I'm looking at this, and that appears to be Wyatt Corey, a signature. Hold that up. Is that your signature?
Yes, Your Honor.
When did you sign this, Mr. Corey?
Yes, Your Honor.
All right. When you signed it, did you understand that it was an agreement to plead guilty, which means that there will not be a trial, and the next step in your case would be a sentencing?
Yes, Your Honor.
All right. And before you signed it, did you go over it with Mr. Kirk and have him answer any questions and explain it to you?
Yes, Your Honor.
And do you feel you had enough time to fully consider the matter before making the decision to sign this document?
Yes, Your Honor.
Do you feel that you were pressured or rushed in any way to do this?
Yes, sir.
And you signed this agreement voluntarily? And are you going forward today and entering the plea of guilty to these 2 charges voluntarily?
Sir.
Right now, it says on page 1 then of the agreement that you're going to withdraw your plea of not guilty, plead guilty to count 5, which is aggravated trafficking of methamphetamine in violation of section 2925.03A1, and count 7, trafficking in cocaine in violation of the same section. Both of those are third-degree felonies. It further states that you understand that if convicted, you could face a potential prison term of between 9 and 36 months on each count, and a fine of $10,000. There is a mandatory fine of $5,000 on each count. And if you receive the maximum sentence and they were ordered to be served consecutively, meaning one after the other, that means that you could face a potential sentence of 9 months minimum if they were run concurrently, up to 72 months maximum if they were run consecutively. Plus, you could be fined $20,000. Do you understand that?
Yes. Yes, Your Honor.
All right. Now, are you facing any felony charges anywhere else?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
All right. Now, under the law, Mr. Corey, if you're convicted of this offense and sentenced of the offenses and sentenced to prison, upon completion of the prison term that was imposed, the adult parole authority has the option, if they decide to exercise it under the law, to put you under post-release control supervision for a period of up to 2 years under the terms and conditions that they set. You'll be supervised then by a parole officer, and if during that period of time they determine that you're not complying with that those conditions, then they can return you to prison as a sanction for those violations to serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. However, if your violations if you are convicted, I should say, of a new felony while on post-release control, and if you are sentenced to prison for that offense, then the sentence in that case could include an additional sentence of 1 year or whatever time is left on the period of post-release control, whichever is greater, for committing that offense while on post-release control in this case. And that sentence additionally could run consecutively to the new sentence in the new case. Do you understand that?
Yes, yes, I do, Your Honor.
All right. Now, there is a presumption that persons convicted of these offenses be sentenced to prison, but it's not mandatory, and so the court does have the right under the law to grant and sentence somebody for these offenses to what's called community control or probation. And that means that instead of going to prison, you'd be put under the supervision of a probation officer under the term set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court and give you a copy. There would be a hearing at which you'd be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and sentence you to between 9 and 72 months. They'd fine you up to $20,000. And if you were convicted of a new felony committed while on community control in this case and received a prison term for that offense, that sentence could be ordered to be served consecutively to the sentence in this case. Do you understand that?
Yes, Your Honor.
All right, now the charge in count 5 alleges that on or about August 14, 2025 in Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in an amount equal to or exceeding bulk amount but less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code. So that is a charge of the aggravated trafficking in methamphetamine. Third-degree felony was the penalty I described earlier. Count 7 alleges on or about August 14, 2025 in Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did knowingly sell or offer to sell cocaine, a Schedule II controlled substance, in an amount equal to or exceeding 10 grams but less than 20 grams, in violation of Section 2925.03A1 of the Ohio Revised Code. So that's a charge of trafficking in cocaine, also a third-degree felony with the penalty I described earlier. Now, Mr. Corey, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
You discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible defenses you may try to raise at trial, and the possible outcomes of the trial with your attorney.
Yes, Your Honor.
Are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to make you plead guilty here today?
No, sir.
All right, now, at the bottom of page 2, there are several lines printed in bold and underlined, and then it looks like parts of those have been whited out and replacement language has been written in ink. So I will read that to you into the record at this time. Defendant will enter a plea of guilty to count 5 and count 7. State will dismiss remaining counts. State defense jointly recommend 12 months incarceration on count 5, consecutive to 12 months incarceration on count 7. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay bond money to the task force in the amount of $860. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today? Now, under the law, Mr. Corey, the matter of sentence is up to the judge, not the parties. And so even though there's a recommendation you should receive 24 months total incarceration on these two charges, under the law, if the court, after hearing everything, decides that's not the correct sentence, you could be sentenced to any term of incarceration between 9 and 72 months, and you could be fined $20,000. Do you understand that?
Sure.
Now, do you hold any professional or any license or certification from any state governmental agency that regulates any profession or occupation in the state of Ohio?
No, Your Honor.
Now, you have certain constitutional rights you must understand before I can accept a plea from you. First of all, you have a right to counsel. I appointed Mr. Kirk to represent you since you did not have the money to hire your own attorney. His appointment wasn't simply to try to work the case out, but provide whatever defense could be available to you under the law that you would like him to provide. So, if you decide you don't want to plead guilty here today, you'll continue to have Mr. Kirk to represent you and defend you, including a trial, if that is what you want. Do you understand that?
Sure.
Now, under the constitutional laws of this state, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence is presented. The judge then instructs them on the law, and then that jury of 12 people has to decide by unanimous verdict, meaning all 12 have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, in which case you would have a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge will apply the law, and the judge will decide whether or not the state proves your guilt. Do you understand that? Right now, Mr. Corey, under the laws and the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in open session in front of you, your attorney, and anyone else that's observing. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Sure.
Now, under the constitutional laws of the state, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena. That forces those people that are named in the subpoena to come into court to testify for you if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution and the laws of the state, Mr. Corey, you have privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that? Now, under the Constitution and laws of the state, Mr. Corey, you are presumed innocent of this charge until proven guilty by the state, or both charges, I should say, until proven guilty by the state of Ohio on each charge of proof beyond a reasonable doubt on every essential element of each offense. So the burden of proof isn't on you to try to prove that you didn't commit these offenses as charged. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that? Sorry?
Yes,
Okay.
I do, Your Honor.
All right, thank you. Now, originally, you entered a plea of not guilty to these charges, Mr. Corey. And that plea denied the allegation in each of the offenses listed in the indictment, denied you committed any crime, and it exercised or invoked all the rights I have just described for you this morning. Now, if you change your plea from not guilty to guilty as to counts 5 and 7, that is the complete opposite of the not guilty plea. The plea of guilty would waive or give up, well, first of all, it would admit the allegations in each count of the indictment that you're entering that plea to, admit that the allegations are true, that they are a crime, and that you committed that crime. And that plea waives and gives up all of the rights that I've described for you except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty, waives, gives up your right to a jury or a court trial. It waives, gives up your right to confront the witnesses against you and to cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, same as the state. Waives, gives up your privilege against self-incrimination because if you say you're guilty of these 2 counts, then that's what's used to find you guilty. It waives, gives up your right to require the state to prove your guilt on either or both charges because if you plead guilty, then the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, which I believe is what's being recommended here. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
Are you a U.S. citizen, Mr. Corey?
I am, Your Honor.
Now, do you have any questions about either of the 2 charges, counts 5 or 7?
No, Your Honor.
You understand you understand the charges,
Yes, sir.
and you understand the possible penalties if you're convicted.
Yes, I do, Your Honor.
You have any questions about the plea agreement?
No, Your Honor.
And you understand the terms of that agreement,
Yes, I do, Your Honor.
and you understand the recommendation on sentencing is not binding on the court.
Yes, I do, Your Honor.
You have any questions about the constitutional rights I've explained?
No, I do not, Your Honor.
Do you understand those?
Yes, I do.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea to counts 5 and 7 here today?
Yes, I do, Your Honor.
You understand? Okay. Now, is there anything you need to speak to Mr. Kirk about before we go any further?
No, I do not, Your Honor.
All right, you have any questions at all before we proceed?
No, I do not, Your Honor.
Then is it your decision, Mr. Corey, to withdraw your not guilty plea to counts 5 and 7 and enter plea of guilty to those counts pursuant to the terms of this plea agreement?
Yes, Your Honor.
And you're doing that voluntarily?
Yes, Your Honor.
All right, then as to the charge in count 5, which alleges an on or about August 14, 2025 in Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, in violation of Section 2925.038 Weather Ohio Revised Code, the charge of aggravated trafficking in methamphetamine, a third-degree felony, carrying a possible prison term between 9 and 36 months, a fine of $10,000, a mandatory fine of $5,000. How do you plead?
Guilty, Your Honor.
As to count 7, which alleges on or about August 14, 2025 in Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did knowingly sell or offer to sell cocaine, a Schedule II controlled substance, an amount equal to or exceeding 10 grams, less than 20 grams, in violation of Section 2925.038 of the Ohio Revised Code, the charge of trafficking in cocaine, a third-degree felony, with the same penalties as I described in count 5. How do you plead?
Guilty, Your Honor.
All right. The court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same, pursuant to Criminal Rule 11. The pleas accepted, order filed. Defendants found guilty of counts 5 and 7 as charged therein. Counts 1 through 4, 6, and 8 through 9 are dismissed. The court will go ahead and proceed with sentencing forthwith. On will not be continued. All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
Mr. Kirk.
Thank you, Your Honor. When I was court to follow the plea agreement, I believe this is my client's third felony conviction. This will be his second time going to prison. Has no prior trafficking charges, and in this case, review of the information appears that while he was trafficking, it was to support a personal drug habit, which is obviously no excuse for the behavior, but would ask the court, given the information available, to follow the plea agreement.
All right, Mr. Corey, anything that you would like to say?
Hey, Your Honor, decided on making a good decision. And I'm sorry, sir. Hope you give people up. I thank God that you guys had mercy upon me.
All right, according to the sheriff's records that I have here, you were arrested on the 17th of May, is that correct?
Yes, Your Honor.
Okay. All right, then it is the order of the court that you be and are hereby sentenced on count 5 to a term of 12 months, and as to count 7 to a term of 12 months of incarceration at the Correction Reception Center in Orion, Ohio. Those sentences are ordered to be served consecutively to one another. The court finds that, first of all, the parties have stipulated to the sentence. Also, the offenses were committed as part of one or more courses of conduct, and that one single sentence will not adequately reflect the seriousness of the offense, and the sentences that are being imposed that are not disproportionate to the seriousness of the effect of the offenses. The defendant's prior criminal history shows that demonstrates that consecutive sentences are necessary to protect the public from future crime, and also that consecutive sentences are necessary to protect the public from future crime or to punish, defend, and again, as I indicated, not disproportionate to the seriousness of his offense and the danger that he poses. The defendant's given credit for 59 days of jail time credit as of today. Now, upon completion of 54 days, not 58. I misread just read the note. Now, upon completion of this sentence, Mr. Corey, it is possible the Adult Parole Authority will exercise the option to place you under post-release control for a period of up to 2 years on the terms they set. If during that period of time they determine that you've not complied, then they can return you to prison to make you serve an additional period of up to 9 months for a single violation, but there is a cap or limit of half of your prison term. So in this case, half of your prison term is 12 months. So that would be the maximum they can impose for one or more violations. But if you're convicted of a new felony while on post-release control and sentenced to prison for that new offense, the judge in that case could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. It's also ordered you pay the court costs once the judgment, grant, and execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you would be permitted to do community service in this county and be given credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. It's also ordered that you pay restitution, or you are sentenced to pay restitution to the task force in the amount of $860. That payment will have to be made through the Hyndman County Victim Witness Restitution Escrow account, and you're paying any fees associated with that. Now, has there been any change in your financial circumstances since I appointed Mr. Kirk to represent you? Have you had any change in your financial circumstances since you were arrested and Mr. Kirk was appointed to represent you?
Yes, Your Honor.
All right. Then the court will find that the defendant is not able to pay the mandatory fine and is unlikely to be able to do so in the near future, and therefore that is waived as to each count. All right. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. You're remanded back to custody then, Mr. Corey. Thank you.
This still works quiet. I think slide.
All right. This is case number 26 CR 55, State of Ohio versus David Bennett. Are you, David Bennett, seated there in the jail video room with your attorney, Mr. Wagner?
Yes, sir.
All right. This hearing is being conducted by Zoom. It's final pretrial. The state's represented by Assistant Prosecuting Attorney King, who's appearing from the prosecutor's office. And Mr. Wagner, are you and your attorney, or you and your client both in agreement that the matter can be conducted by Zoom rather than being brought up to the courtroom for an in-person hearing?
We are, sir.
And you're all right with that, Mr. Bennett?
Yes.
All right. So Mr. Bennett is charged with 1 count of aggravated trafficking of methamphetamine, third-degree felony, and 1 count of theft by deception, a first-degree misdemeanor. This matter is set for trial sometime later this month. It looks like July 23rd. I have a plea of guilty form here. that indicates you're going to plead guilty to count 1, Mr. Bennett. It's a 3-page document. I'm going to hold page 1 up to the camera. It has your title of your case and case number, and a plea of guilty to count 1. Do you recognize that document?
Yes, sir.
On page 3, there's a line that reads, enter this plea voluntarily. And below that, there's a line for signature defendant. And it looks like David Bennett. Is that your signature there on that line? I'm sorry?
Yes, sir.
When did you sign this, Mr. Bennett?
Your reading about last week, this is a continued plea. He had a question in the middle of the one last week. So
Oh, that's right. I forgot. Okay. All right. And so you understand this is an agreement to plead guilty, meaning there's not going to be a trial, and the next step in your case is going to be a sentencing hearing. Here. Do you understand that?
Yes, sir.
All right. And you feel you had enough time then to fully consider the matter and talk with Mr. Wagner about this before you signed it?
Yes, sir.
And since you signed it a few days ago, we did continue that hearing so you could have further time to consult. You feel now this is what you want to do and you want to go forward with this plea?
Yes, sir. I just have one other question.
What's that?
My last 6 months in the penitentiary, could I get to that?
Your Honor, he would just, I'll save that for the end, for the offer mitigation, Your Honor.
Okay. All right. So you've had enough time to fully consider the matter before making this decision? Thank you.
Yes, sir.
And you're going forward today then voluntarily?
Yes.
All right, so on page 1 it says you're going to withdraw your not guilty plea to count 1 and plead guilty, and that is a charge of aggravated trafficking of methamphetamine, a 5th-degree felony. It states that you understand that carries a possible sentence of between 9 and 36 months of imprisonment, a fine of $10,000, and a mandatory fine of $5,000. And this is not a mandatory prison term offense, but it is presumed that prison term should be imposed. Do you understand that? Are you facing any felony charges anywhere else, Mr. Bennett?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, the matter, if you are sentenced to prison, if you're convicted for this offense and sentenced to prison, then upon completion of the prison term imposed by the judge, the Adult Parole Authority has the right to to put you under what's called post-release control for a period of up to 2 years under the terms and conditions they set. And if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation, but there is a cap or limit of half of whatever the prison term that you served was. However, if you are convicted of a new felony and receive a prison term, then upon the judge in that case then, because you committed that offense while on post-release control in this case, could sentence you to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater, and that would have to be served consecutively to the sentence in that new case. Do you understand that?
Yes.
Now, as I said, Mr. Bennett, this is not a mandatory prison offense, and so the court does have the right to place a person convicted of this offense under what's called community control, although, again, it's presumed that prison is the correct sentence. So instead of, if you were sentenced to community control instead of prison, that means you would be put under the supervision of a probation officer under terms set by the court for up to 5 years, and if during that period of time the probation department felt you were not complying, they would file a written allegation with the court. There would be a hearing in which you would be entitled to have an attorney, and if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period of 9 to 36 months, fine you $10,000. Do you understand that?
Yes, sir.
Oh, and also I should say that in the event that you were convicted of a new offense committed while on community control and received a prison term, sentences in the new case and this case could be ordered to be served consecutively to one another. Do you understand that?
Yes, sir.
All right. Now, the charge in this case, Mr. Bennett, alleges that on or about September 24, 2025 in Hiding County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount no less than 5 times bulk amount in violation of Section 2925.03A1 of the Ohio Revised Code. So that's the charge that you're facing with the penalties I described earlier. Now, do you understand what it is you're charged with, what the state said you did, when, where, and how they alleged you did it?
Yes.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise at trial, possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty here today? Now, on page 2, there are little over 3 lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1. State will dismiss count 2. State and defense jointly recommend 12 months incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force in the amount of $60. Is that your understanding of the agreement?
Yeah, once this agreed to task force, right?
May I address that, Your Honor?
Yeah.
Well, we're good, sir.
All right. So is that your understanding of the agreement then?
Yes.
Anyone promise you anything other than that gets you to plead guilty?
No.
Now, under the law, the matter of sentence is up to the judge, not the parties, Mr. Bennett. So even though there's a recommendation that you receive a 12-month sentence, the court's not bound by that. And the court could, after hearing all the information presented, decide that's not the correct sentence under the law and the facts. And you can be sentenced to any sentence between 9 and 36 months and fine $10,000. Do you understand that? I'm sorry?
Yes.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
Now, you have certain constitutional rights you must understand before I can accept a guilty plea. First, you have a right to counsel. Mr. Wagner was appointed to represent you because you did not have funds to hire your own attorney. Now, his appointment wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you would like him to provide. So if you decide that you do not want to do this, that you would rather defend against the charge, he'll continue to represent you and defend you, including a trial if that's what you decide you want. You understand that?
Yes.
Now, under the Constitution and the laws of this state, you have a right to have a jury trial in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After those 12 folks are selected, the evidence is presented, the judge instructs them on the law. And then that jury has to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means you give up the right to have a jury trial, in which case you would have what's called a court or bench trial, meaning instead of a jury, would be the evidence, or would be the judge would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that? Now, under the Constitution and the laws of this state, you have a right to confront the witnesses against you and to cross-examine them in open court through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that's observing. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that? Now, under the Constitution and the laws of the state, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're not certain are going to come in voluntarily at your request, that a court order is issued, a subpoena, forces those people that you've named in the subpoena to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a presumption of innocence, which means that you're presumed innocent until and unless the state proves your guilt or proof beyond a reasonable doubt on every essential element of the offense charged. So the burden of proof isn't on you to try to show you're not guilty because you've been accused. In fact, under the law, you don't have to present any evidence at trial whatsoever. You can, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally, you entered a plea of not guilty to this charge. The plea of not guilty denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've described for you today. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. Now, a guilty plea then would admit the allegation in the indictment, admit that it's a crime, and that you committed that crime, and that plea waives, gives up all of the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, a plea of guilty waives gives up your right to a jury or court trial. It waives gives up your right to use the power of the court to compel or force witnesses to be here to testify for you, the same as the state. Waives gives up your right to confront witnesses against you in open court and cross-examine them through your attorney. Waives gives up your privilege against self-incrimination, because if you say you're guilty, then that's what's used to find you guilty. The waives gives up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal that you feel you may have had up until this point in the case. Now, if you are sentenced to the maximum sentence or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge or the possible penalties, Mr. Bennett?
No.
You understand them?
Yes.
You understand the constitutional rights I've explained to you?
Yes.
You understand the plea agreement?
Yes.
You understand that the recommendation on sentence is not binding on the judge?
Yes.
You understand the plea of guilty, what it means, and what will happen if you enter that here this morning?
Yes.
Then is it your decision to go forward and plead guilty according to the terms of the plea agreement that we've just gone over?
Yes.
Then as to the charge in count 1, which alleges that on or about September 24, 2025 in Howling County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, an amount equal to or exceeding bulk amount, or less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, a third-degree felony carrying a possible prison term between 9 and 36 months, fine of up to $10,000, a mandatory fine of $5,000. How do you plead?
Guilty.
All right, the court finds on this date, open court, defendants advised of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Pleas accepted in court of file. Defendants found guilty of count 1, the third-degree felony is charged. Count 2 is dismissed pursuant to the plea agreement. The court will go ahead and proceed with sentencing forthwith. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
Mr. Wagner?
We would ask the court to follow the recommendation of the parties. Once I did inherit this case, got time spent with Mr. Bennett, we were able to resolve this. His only hesitation in the last hearing, Your Honor, was not to be difficult. He simply just had a request, and he wanted to echo it again today, Your Honor, that should he be eligible for transitional housing as he gets to the tail end of his prison sentence, that the court consider it or allow him to complete the transitional housing. That's all.
Okay. With regard to that, I will say that in my almost 18 years now on the bench, I think I've denied transitional control maybe twice. So I always approve it. So I think it's in the best interest of the offender and the society that occur. So, as far as I'm concerned, if you're eligible and they want to put you there, that will be fine. Although I may not be judged by then, but so that could change. But that's generally been my policy. All right. Now, according to the sheriff, do you have anything you'd like to say, Mr. Bennett?
No.
All right. According to Sheriff, you're arrested on May the 6th. Is that correct?
Yes.
All right. It's the order of the court, then, that you be and are hereby sentenced to a term of 12 months of incarceration at the Correction Reception Center in Orion, Ohio, and you'll be given credit for 63 days of that sentence. Now, upon completion of that sentence, Mr. Bennett, it's possible the adult parole authority may choose to put you under post-release control for a period of up to 2 years on the terms they set, and if they do, you'll be supervised by a parole officer, and if they determine that you have failed to comply, they could even turn you to prison to make you serve as a sanction of additional period of up to 6 months for one or more violations. But if you commit a new felony while on post-release control and are sentenced to prison, then that judge in that new case could sentence you for committing that offense while on post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater, in that case, that sentence would be ordered to be served consecutively as sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, and other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you are released, the court could permit you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. You're also ordered to pay restitution to the sentence to pay restitution to the task force in the amount of $60, and that will have to be paid through the Highland County Victim Witness Restitution Escrow account. You'll pay the fee associated with that. All right, is there anything further from counsel?
No, sir.
All right, you're remanded to custody, Mr. Bennett. Thank you. Well, then bring Mr. Tedford in. We'll do that.
Yeah. Can we hold off on Tedford? Till 10 o'clock. There's a victim on that case.
Oh, yeah. Okay. I'm sorry. Yeah, we'll have to wait till 10 on that one, Mr. Wagner. So go ahead and have him get Mr. Neal.
I've got Mr. Neal, sir. Maybe a second.
Mr. Wagner, before you close that door, would you ask the deputy to get Mr. Moberly up, and because we have to wait till 10 to do the Tedford case, so we can go ahead and arraign Mr. Moberly then.
There you got him up, sir. Yes.
All right. Thank you.
All right.
All right, this is case number 26 CR 059, State of Ohio versus Donald Terrence Neal III. Are you Donald Terrence Neal III, appearing there from the jail with your attorney, Jacob Wagner?
Yes, I am.
All right, the state is represented by Assistant Prosecuting Attorney King. The defendant is charged with rape, first-degree felony. Mr. King, has the alleged victim or representative of the alleged victim been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor. She's elected not to attend the hearing this morning.
All right. So this matter was put on the docket at the request of the parties for a proposed stipulated polygraph. And I have in front of me an agreement. Mr. Neal indicates agreement and stipulation in this case and has your name, case number. I'm going to hold it up to the camera and ask if you recognize that document, this first page of the document.
Yes, Your Honor.
All right. And then on page 3, it says freely and voluntarily agreed and stipulated this 7th day of July 2026. Defendant, there's an X, has Donald T. Neal III, and I'll hold that up to the camera. Is that your signature?
Yes, it is.
And you signed this yesterday?
Yes.
All right. Now, Mr. Neal, normally the results of a polygraph are not admissible in a court trial. But there is an exception under the law that allows for what's called a stipulated polygraph, which is what this agreement is. And what that allows then is that you would take a polygraph and answer certain questions regarding the allegations, and then in the event that there is a trial of this case, the results of that polygraph could then be admitted to determine for the jury to determine whether or not at the time you answered those questions you were being truthful. And so if you take this polygraph examination and the results say that you were truthful, and those results are then are admissible on your behalf in the case. If they say that you were not being truthful or being deceptive or whatever term of art the particular examiner uses, it says that basically you failed or were not telling the truth on whatever questions he or she determines that occurred, then the state can introduce that in their case against you. So if you take the polygraph and they determine that you were being truthful, doesn't mean your charge is necessarily dismissed. It means that at trial the results could be admitted. So on the other hand, if the examiner determines you were telling the truth, you were lying, doesn't mean that you are automatically guilty. You still will have a trial, but the results of that could be admissible for the purpose of determining whether at the time you took the test you were being truthful. Now, do you understand all that?
Sure.
All right. You discussed this with your attorney and decided this is what you want to do?
Sure.
All right. Then it looks like it's set up for July the 16th at 8:30. What date is the trial in this case?
We had to reset it. It's mid to late August, Your Honor.
August 10 and 11. I see that. Okay. All right. Then the court will approve this, and I've signed the entry. I'll also then sign the entry of removal, or warrant of removal, for the Sheriff's Department to transport Mr. Neal to the Ohio State Highway Patrol, 1970 West Broad Street, on July 16th for the purpose of being administered this polygraph examination. All right. Anything further from counsel?
No, Your Honor.
All right. Thank you. Is there an alleged victim or victims in this case, Mr. King?
No, Your Honor.
All right. These are internet allegations?
Correct.
All right. All right, this is case number 26, CR 76, State of Ohio versus Levi Dean Moberly. And are you Levi Dean Moberly appearing there from the jail with Mr. Wagner?
Yes, sir.
All right, and Mr. Wagner, my understanding is you have been retained to represent the defendant?
I'm supposed to meet at 8 o'clock this morning, yes, Your Honor.
All right. The state is represented by Assistant Prosecuting Attorney King. This is an arraignment. Mr. Moberly was indicted on July the 7th for 5 counts of pandering obscenity involving a minor. And I did ask Mr. King off the record while you were getting your client, but also I'll confirm it here. There is no actual victim or representative of any victim in this case, Mr. King.
That's correct, Your Honor.
All right. So these are basically allegations of photographs from the internet?
Yes, sir.
All right. All right. So the defendant is charged with 5 counts of pandering obscenity involving a minor under 2907.321A2, all second-degree felonies. In this case, they carry a possible prison term as a minimum set by the judge of 2 to 8 years, with potential of any sentence being imposed being extended by up to 1/2, and a fine of $15,000 on each count. Are these mandatory sentences? I don't think they are they?
I don't believe so, Your Honor. I'm not 100% sure, but I don't believe so.
Yeah, at this point, at least, I don't think so. We'll confirm that later in the case. All right, Mr. Wagner, you've had an opportunity to review the indictment with your client. Do you wish to?
complaint and are not guilty at this time of all counts.
All right. When was he served with the indictment?
He got picked up last night about 2 o'clock last night. We waited 24 hours.
All right.
Requirement.
And your plea?
Not guilty to all counts, Your Honor.
All right. We'll set the first pretrial in this case for August the 5th at 1 p.m. Final pretrial will be September the 2nd at 1 p.m. Trial date will be October the 13th. Now, wait a minute. Well, that would be outside of the speedy trial limit, so we will have to set it early. And plus, I'm going to be out of the country then anyway. So we'll set the trial date for September the 17th at 8 a.m. All right. State wish to be heard regarding bond.
Yes, Your Honor. The state is requesting that bond be set in the amount of $100,000. That's all. Thank you.
All right, Mr. Wagner.
Your Honor, we respectfully ask the court, I guess I say it this way, I'm well aware, my client is aware, Your Honor. These are evidence that they carry 2 to 8 years, very serious charges, we acknowledge that. But Your Honor, I would say I met Levi last week, came to my office. He was well aware of the state's investigation. I came in and consulted with me. He and his fiance. He didn't flee, didn't run, didn't take off and run to Mexico. Again, I'm not trying to be funny there, but that's what a lot of people think. Serious charges that will take off. He did, and he actually booked an appointment with me for this morning at 8 o'clock. He did not show up at 8 o'clock, actually. He called me at 2 o'clock last night on my personal cell phone. The point I'm making, Your Honor, is he's been in my office, he's already called me, he had an appointment set up this morning, he has a fiance, he works in Columbus, he has 3 children, he's got ties in the community, he is not a flight risk, Your Honor. We would simply ask the court for an OR bond or something that he could make monetarily. $100,000 is like $10 million, Your Honor. He can't make that.
Where is he employed?
The garage door company.
Airborne Equipment. This company based out of Cincinnati.
And you're working in Columbus right now?
Yes, sir.
All right. And there's no previous criminal history, Mr. King, that you're aware of? I don't see any.
I haven't looked into his criminal history, Your Honor, so I really don't know.
All right. Well, the court network, our court network, doesn't show any reports of any previous history.
Your Honor, he's indicated maybe some traffic violations.
Yeah. Well, we wouldn't have those. This is just for criminal cases. All right. Bond's going to be set in the amount of $20,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony, and if sentenced, convicted, sentenced on that, no matter what happens in this case. Be required to pay a deposit of $116 for certain statutory required fees. If you do make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You'll be required to report to them immediately upon your release. Report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, employer. Recommended by probation be evaluated for substance abuse or mental health issues. If any treatments indicated, you're to enroll in and follow that during the pendency of this action. And what is your residence address, Mr. Moberly?
My home address is 3344 Sharpsville Road, Lynchburg, Ohio.
All right, so you'll be under house arrest at that residence unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with your attorney or probation officer in this or the case, can attend any kind of schooling, job training, educational programming, church services, and children's activities. Other than that, you have to be there at all times. And if you fail to comply with these conditions, then the court could revoke that bond and have you held to further order of court. All right. Is there anything further then from counsel?
No, Your Honor.
Just a question, was that straight 20,000 cash bond, or did you approve
20,000, I said.
20? Okay.
20,000. Cash, surety, or property. Yeah.
Yes, sir. Thank you.
All right. Thank you. All right. All right, this is case number 26 CR 34, State of Ohio versus Jeffrey E. Tedford Jr. Are you Jeffrey E. Tedford Jr. appearing there from the jail in the video room with Jacob Wagner, your attorney?
Yes, sir.
All right, this is a pretrial being conducted by Zoom. The defendant's representatives indicated Mr. Wagner is present at the jail with his client and present on behalf of the state from the prosecutor's office, Assistant Prosecutor King. This hearing is being conducted by Zoom, and Mr. Wagner, you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom.
We are, sir.
And you're all right with that, Mr. Tedford?
Yes, sir.
All right. Mr. Tedford is charged with grand theft of a motor vehicle, a fourth-degree felony. Mr. King has the alleged victim or the representative of the alleged victim been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, she has, Your Honor. I thought she was going to attend this hearing this morning, but she's not present, so apparently she's elected not to.
All right. Now, Mr. Tedford, I have here a proposed plea of guilty form. It is 4 pages. It has page 1, your case number, your name, and plea of guilty. I'm going to hold that up to the camera on my computer and ask you if you recognize that document. I'm sorry?
Yes, sir.
Okay. And on page 3, the last sentence on that page is written, I enter this plea voluntarily. Below that, there's a line for signature of defendant, and there's an X on the line, and then the signature appears to be Jeffrey Tedford. Is that your signature there? I'm sorry?
Yes, sir.
Okay. You're further away from your microphone than I am, and so sometimes I don't quite hear you, and I want to make sure that I can make it out, but I need to make sure that the recorder gets it. So if you would, just keep your voice up when you answer. Now, Mr. Tedford, when did you sign this agreement?
Yesterday.
All right.
Yesterday.
All right. When you signed this agreement, Mr. Tedford, did you understand it's an agreement to plead guilty, meaning there won't be a trial, and the next step in your case will be a sentencing?
Yes, sir.
And before you signed it, did you go over it with your attorney and have him explain it to you and answer any questions?
Yes, sir.
Do you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
And since you signed it yesterday, have you had any change of mind, or is this still what you want to do?
Yeah, I want to go on.
And you're doing this voluntarily?
Yes, sir.
All right, so the agreement states on page 1, you're going to withdraw your not guilty plea, plead guilty to the charge, of grand theft of motor vehicle under section 2913.03, 2913.02 A1 of the Ohio Revised Code, a 4th-degree felony. It states that you understand that the possible penalty for that would be between 6 and 18 months in prison and a fine of $5,000. You understand that?
So,
Now, Mr. Tedford, are you facing any felony charges in any other jurisdiction?
yes, sir, I'm facing failure to comply and
All right. A failure to comply? And you're waiting trial in those cases or next?
I had my first free trial.
Okay. Well, in the event that you are convicted in this case and sentenced to prison, and if you are convicted in Adams County, I know if you're convicted of failure to comply, under the law it's required that that sentence be served consecutively to any other prison term you are given. And if there's another charge that you're convicted of and sentenced to prison, it could be ordered to be served consecutively as well. And consecutive means each sentence will be served one after the other. You understand that?
Yes, sir.
All right. And other than the pending charges that you've described, are you on probation or community control, parole, or post-release control for any felony in the state of Ohio?
No, yes, sir.
All right. Under the law, in this case, Mr. Tedford, if you are convicted and sentenced to prison, upon completion of that prison term, it is possible the Adult Parole Authority would put you under post-release control after released. And what that means is that you are supervised by a parole officer under the terms they set. If during that period of time they determine that you have not complied, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, but there's a cap or limit of half of whatever the prison term was for all violations. But if you are convicted of a new felony while on post-release control and sentenced to prison, then in that event, the judge in that case could sentence you for committing that offense while on post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, I'm not required to sentence a person convicted of this offense to prison. I can impose community control or probation, which means instead of going to prison, you'd be put under supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time the probation department felt you were not compliant, they would file a written allegation of that with the court. You would get a copy. There would be a hearing at which you'd be entitled to have an attorney. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period between 6 and 18 months, fine you $5,000, and if you were convicted of a new felony committed while on community control in this case and received a prison term, the sentence in that term, in that case, can be ordered to be served consecutively to the sentence in this case. You understand that?
Yes, sir.
Now, the indictment alleges that on or about January 21, 2026 in this county, you did with purpose to deprive the owner, V, of their property, knowingly obtain or exert control over the property, to wit, a 2005 Ford Ranger, a motor vehicle as defined in ORC section 4501.01, the Ohio Revised Code, without the consent of the owner or a person authorized to give consent, in violation of section 2913.02A1. So that's the charge of 4th-degree felony with the penalty that I've described for you. Now, do you understand what it is you've been charged with, what state said you did, when, where, and how they allege that you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
On page 2, there are a couple of lines, a little more than 2 lines, printed in bold and underlined with an additional figure written in by ink. So I'll read that into the record at this time, and it reads as follows. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend 12 months incarceration. Defendant agrees to pay restitution to V in the amount of $5,674.68. Is that your understanding of the agreement?
Sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, the matter of sentence is not up to the parties, it's up to the judge, and so even though there's a recommendation for a sentence of 12 months, that recommendation is not binding on the court. So if you plead guilty, the court's not required to follow that. You could be sentenced to any term between 6 and 18 months and fined $5,000. Do you understand that? Now, you have certain constitutional rights you must understand, Mr. Ted Ford, before I can accept your plea. First of all, you have a right to have an attorney, and Mr. Widener was appointed to represent you since you did not have the money to hire one. Now, his appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you're likely to provide. So if you decide you don't want to do this, that you'd rather defend against the charge, he will continue to represent you and defend you, including a trial if that's what you want. You understand that? I'm sorry, I didn't hear you.
Yes, sir. Yes,
Okay,
sir.
thank you. Now, I didn't ask you this. I need to go back just a moment. Do you hold any license or certification from any state governmental agency that regulates any occupational profession in the state?
No, sir.
All right, now you have the right to have a jury trial in this matter, Mr. Ted Ford, which means that 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence is presented, they're instructed on the law, and then that jury of 12 decides by unanimous verdict, meaning all 12 have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial, in which case you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that? I didn't hear you.
Yes, sir.
Okay.
Yes, sir.
Now, under the laws and the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to appear and testify in front of you, your attorney, and anyone else that's observing, because it's an open hearing. At the conclusion of the prosecutor's questioning of the witnesses, your attorney can ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution and laws of the state, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena. That forces those people to come into court to testify on your behalf if you want them to, even though they don't want to be here. It's the same way the state's witnesses are forced to come in and testify against you. Do you understand that? Now, under the Constitution and laws of the state, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it during the proceedings, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution and the laws of the state, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charge. So, the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all in your own defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, sir.
Now, originally, Mr. Ted Ford, you entered a plea of not guilty, which denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. If you change your plea here today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed the crime. That plea will waive or give up all the rights I've described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. It Would waiver give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state? Would waiver give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty? Would waiver give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty? It also subjects you to being sentenced immediately by the court. And finally, it waiver gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence or under other certain circumstances, an appeal could be filed. That would have to be filed within 30 days of your sentencing entry being filed. And finally, it subjects you to being sentenced immediately by the court. Now, do you understand all of that?
Yes, sir.
Are you a U.S. citizen, Mr. Tedford?
My what?
Are you a U.S. citizen? All right. Now, do you have any questions about the charge or the possible penalties?
No.
You understand it? You have any questions about the plea agreement?
No.
You understand it?
Yes, sir.
Do you have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, sir.
Have any questions about the guilty plea, what it means, and what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
And again, you understand that if you go to prison on this charge and then later are convicted in Adams County of failure to comply, that is a mandatory consecutive sentence.
Yes, sir.
You understand that?
Yeah.
Okay, all right. Now, is there anything you need to speak with Mr. Wagner about before we go any further?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this plea agreement that we've just gone over? All right, then as to the charge, which alleges that on or about January 21, 2026 in Highland County, Ohio, you did with purpose to deprive the owner V of their property, knowingly obtain or exert control over the property, to wit a 2005 Ford Ranger motor vehicle, as defined in the ORC section 4501.01, without the consent of the owner or person authorized to give consent, in violation of section 2913.02A1 of the Ohio Revised Code. The charge of grand theft of a motor vehicle, a fourth-degree felony, carrying a possible prison term between 6 and 18 months, fine of $5,000. How do you plead?
Yes.
All right. The court finds that on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. The pleas accepted or ordered filed. Defendants found guilty of the charge. All right. Based upon the recommendation of the parties, the other circumstances Mr. Tedford's facing, the court's going to go ahead and proceed with sentencing forthwith. Anything? And Mr. King, I didn't ask, but did the victim of the offense, was he or she consulted and concur with the disposition here?
She was consulted, Your Honor. It was discussed with her. She advised she wanted the defendant to receive the maximum sentence, however.
All right. Anything further from the state?
Only was contained in the plea agreement, Your Honor.
Mr. Wagner?
Your Honor, I would only shed a little bit of light on the pending Adams County case. I don't know if it makes it any better or worse, but these acts all stem from the same incident. Just a bad night, Mr. Tedford. Again, that does not justify his actions. But I think what is important, though, Your Honor, is if you look at this just ahead of the schedule, action at the docket, as far as resolving this case. The second pre-trial is coming up next week. Mr. Tedford and I have been talking about the case. He wanted to resolve it, take full responsibility for his actions. He indicates he was the individual responsible, and he's not trying to hide behind that judge. Again, he's moved this case up fast in the docket. He's a month ahead of the jury trial. He wants to resolve it and take responsibility, sir.
All right, Mr. Tedford, is there anything you'd like to say?
No, sir. No.
All right, and according to the sheriff, we've had you in custody for 35 days from June the 4th. Is that correct? Okay. All right, it is the judgment order of the court, then, that defendant B is hereby sentenced to a term of 12 months of incarceration in Correctional Reception Center in Orion, Ohio. He'll be given credit for 35 days, jail time credit since June 4th. Upon completion of this prison term, Mr. Ted Ford, it is possible the adult parole authority will put you under post-release control supervision under terms they set for a period of up to 2 years. If they do, and you are determined to have failed to comply with those conditions, they can return you to prison as a sanction and make you serve an additional period of up to, in this case, 6 months for one or more violations. However, if you are convicted of a new felony and receive a prison term, upon completion of that prison term, the adult parole authority could put you under post-release control for a period of up to 2 years, and if during that period of time, as I said, I'm repeating myself. If you are convicted of a new felony during that period of time and receive a prison term, then the judge in that new case could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence of the new case. It's also ordered you pay the court costs, which judge will grant an execution order. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, once you get out, then you can be permitted to do community service in this county and be given credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. It's also ordered that you make restitution to the victim, in this case, in the amount of $5,674.68. That'll be payable through the Highland County Victim Witness Restitution Escrow account, and you'll pay any fees associated with that. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody then. All right, case number 26 CR 71, State of Ohio versus Austin T. McIntyre. Are you Austin T. McIntyre appearing there from the jail?
Yes, Your Honor.
All right, Mr. McIntyre, you were indicted by the grand jury on July the 7th on a charge of failure to comply with order signal police officer, a third-degree felony. Alleges that occurred on or about May 21st of this year, and that also is continuing course in Hyden County and continuing course conduct in Brown County, at which time it's alleged you operated a motor vehicle so willfully to elude or flee a police officer after receiving a visible or audible signal to bring it to a stop, and that operation causes substantial risk of serious physical harm to persons or property. That is a third-degree felony, Mr. McIntyre, which carries a possible term of incarceration if convicted of between 9 and 36 months and a fine of $10,000 and a mandatory license suspension of anywhere from 3 years to life. You are entitled to have an attorney to represent you. If you don't have the money to hire one, the court will appoint one. I see you did fill out a financial disclosure form. Is everything on this form correct?
Yes, Your Honor.
All right, the court then will find that you are entitled to appoint counsel. I'll appoint Attorney Dennis Kirk of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a bond review hearing on your case for July the 10th, Friday, at 8:30 a.m. That'll be by Zoom. We'll set your first pre-trial for August 5th at 1 o'clock p.m. Final pretrial will be August the 19th at 1 o'clock p.m. Gotta check something here. Okay. Now I'm going to have to readjust that schedule because of speedy trial time. So we'll set your first pretrial for July the 15th at 1 o'clock. Final pretrial will be August the 5th at 1 o'clock. And your trial will be August 20th at 8 a.m. Bond will be set in the amount of $10,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case. You'll also be required to pay a deposit of $171 prior to release. And if you make bond, then you'll be under pretrial supervision of the probation department at 117 East Main Street. You report to them immediately after release, and then report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer. If recommended by probation, you'll be assessed for substance abuse or mental health issues. If any treatments indicated, you'll be required to enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work. Medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this the case. You can also attend any kind of job training, educational programming, classes of any sort. You can also attend church services. Other than that, you have to be there at all times. We'll notify your attorney of his appointment, and your hearing will be 8:30 Friday morning on bond review. Thank you. All right, that's Crutcher. All right, get a hold of Denny and let him know. He's going to probation, I take it? All right. So Denny has a 10:30, so ask them downstairs to tell him that Mr. Crutcher is here via probation, so as soon as he can get back to his office, sign into the original Zoom, and we'll do it on that. All right, so I've got it back open. And then let Adam know. Okay, this is case number 26 CR 36, State of Ohio versus Ronald Crutcher Jr. And are you Ronald Crutcher Jr. appearing there from the probation department?
Yes, sir.
All right. This is a hearing on a motion for intervention in lieu of conviction. The defendant is appearing remotely from the probation department. The defendant's attorney, Dennis Kirk, appearing from his office. And appearing on behalf of the state is Assistant Prosecutor King from his office. The matter, as I indicated before the court on a motion for intervention in lieu of conviction, the charge is aggravated possession of methamphetamine. The court did receive a report from the probation department and a report indicating that he is currently in treatment at the Recovery Council. Mr. Kirk, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, Your Honor.
And you're all right with that, Mr. Crutcher?
Yes, sir.
All right. Since you're not seated in the courtroom next to him, if at any time during this hearing you need to speak with him, you let me know, and I'll put the two of you in the breakout room. It'll be just the two of you on the screen. No one else will be able to see you or hear you. Okay?
Yes, sir.
All right. So I have this plea of guilty form, Mr. Crutcher, that indicates you're going to plead guilty in exchange for being placed into the intervention in lieu of conviction program. I have this document's 4 pages long. I'm going to put page 1 up to the screen and ask if you recognize that document.
Yes, sir.
All right. And on page 3, there's a line that reads, I enter this plea voluntarily, and below that is a line for signature, and it looks like Ronald Crutcher Jr. I'm going to hold that up to the screen. Is that your signature?
Yes, sir.
When did you sign this document, Mr. Crutcher?
In my attorney's office. I'm not exactly sure what the date was.
All right. At the time you signed it, did you understand it was an agreement to plead guilty, meaning there's
Yes,
not
sir.
going to be a trial, the next step would be disposition?
Yes, sir.
And before you signed it, did you go over it with him and have him explain it to you?
Yes, sir.
Since it's been a while since you signed it, have you had any change of heart, or is this still what you want to do?
Yes, sir. So, no, I have no change of heart. That's my plea.
All right. So, Mr. Crutcher, under the law, if a person pleads guilty or is convicted after a trial, then they are sentenced. The sentence in this case for aggravated possession of methamphetamine could be between 6 and 12 months and a fine of $2,500, or it could be community control or probation. Once that sentence is pronounced, then that is a felony conviction. Now, there is a provision under the law that if someone committed an offense and their abuse of drugs and or alcohol or mental status was such that contributed to the commission of the offense, and if they are in a certified treatment program, which you are at the Recovery Council, then in that event, the court can, instead of finding a person guilty when they plead guilty, grant a motion for intervention in lieu of conviction. And what that means is you plead guilty, the plea is filed in the case and is public record, but there is no sentencing. The court instead stays the proceedings. That basically means freezes them and waits for a report from the probation department regarding your progress. And in this program, you have to comply with certain conditions of supervision, but those are fewer and less restrictive than if it was a person who had been convicted. You're also required to comply with the treatment plan that you have at the Recovery Council, and that also includes a requirement that you not use any drugs or other substances without a legal prescription for at least 1 year. And and this can be stayed for a period of up to 5 years. I go 2 years because I think 2 years is a long enough time to determine if a person is going to get sober and stay sober and comply. But it could be up to 5 years. Now, the advantage of that program is that if you plead guilty and go through your treatment plan and you're successful and you comply with the conditions, you pay your court costs, then once the court's notified of that, the case against you is dismissed. And even though there was a plea of guilty form in the file, there's no conviction until a sentencing entry is placed. And if the court's notified you've completed everything successfully, then the case is dismissed. So you were never convicted. And then the court will also typically set the matter for a hearing to seal the record because you're eligible to have it sealed if you are successful. Now, in the event that the probation department or your treatment provider says you're not compliant, there's a written notification filed with the court. You're given a copy of that. There's a hearing in which you have an attorney. And if the outcome of the hearing is that you failed to comply with either the condition of supervision or your plan or both, then the court at that time can terminate you from the intervention program, and at that time you are found guilty and then can be sentenced. And because that would then result in a criminal conviction, you have to understand, and that's why we go through this process now. Are you understanding everything so far?
Yes.
Okay.
Yes,
So, under the law, the charge, as I said, carries the potential sentence of 6 to 12 months and a fine of $2,500. And in the event that you should ever be sentenced to prison, if you are on this offense, upon completion of that prison term, the adult parole authority could put you under post-release control supervision for a period of up to 2 years under terms they set. And if you violated those conditions, then they could return you to prison to make you serve an additional period of up to half of whatever the term of incarceration was for one or more violations. But if you are convicted of a new felony while on post-release control and receive a prison term, then in that event, the judge in that case could sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater, which would have to be served consecutively to the sentence in the new case. Do you understand that?
yes, yes, sir.
Okay. Now, as I indicated to you, if the probation department feels you're not complying, if you're in this program, then you have a hearing and I could then find you guilty. Then at that time, you would be subject to being sentenced to 6 to 12 months incarceration, $2,500 fine, or community control or probation. Now, that means that you would not go to prison even though you violated the conditions of your treatment plan or supervision. But instead, you would be put under supervision of the probation department as a felony offender, which is there are many more conditions, and they are more restrictive. That could be for a period of up to 5 years, and if during that period of time that you're being supervised, they felt you're not compliant, then it works the same way as it does for your intervention. They have to file a written notice with the court, give you a copy. There's a hearing. You're entitled to have an attorney at that hearing. If the outcome of that hearing is that you fail to comply with your probation or community control, then it could be revoked, and you could then be sentenced to incarceration of 6 to 12 months, fine $2,500. And if you were convicted of another felony offense while on community control, in this case, and it's also sentenced to incarceration in that case, it could be ordered to be served consecutively to the sentence in this case. You understand that?
Yes, sir.
All right. Now, the charge against you is that on or about February 1, 2026 in this county, you knowingly obtained, possessed, or used a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 of the Revised Code. So that's a charge, as I've indicated to you, of aggravated possession of meth with the penalties I've described. You understand what it is you're charged with, what the state said you did, when, where, and how you alleged that you did it?
Yes, sir.
You discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of the trial with your attorney.
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, sir.
Now, other than being promised that if you plead guilty, you'd be put into the intervention program instead of conviction, has anyone promised you anything?
No, sir.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right, now, because this is your last chance to stand on your not guilty plea, the court has to explain to you your rights. And as I said, you have the right to have a counsel, and I appointed Mr. Kirk to represent you, not simply to try to work the case out, but to provide whatever defense may be available to you under the law that you'd like him to provide. So if you decide you don't want to do this, he'll continue to defend you, including a trial, if that is what you want. Do you understand that?
Yes, sir.
Now, under the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence is presented, the judge instructs them on the law, and that jury of 12 decides by unanimous verdict, meaning all 12 have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, in which case you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have the right to use the power. You have the right to confront the witnesses against you in open court, to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Now, under the law, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, then your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Under the Constitution and the laws of the state, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. And if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to talk about that during the proceedings, with one exception. If there is a jury trial and you don't testify, the judge does instruct the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the law and the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of this offense. So the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any defense at your trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, which denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I just described. If you change your plea today from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime. And that plea waives, gives up all the rights that I've described for you today, except your right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. Waive or give up your right to confront the witnesses against you in open court and to cross-examine them through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. It waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, in the future, if the court sentences you to a maximum sentence if you're convicted, or under other limited circumstances, an appeal could be filed. It would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Do you have any questions about the intervention plan or program or what's required of you?
No, sir.
Do you understand?
Yes.
Have any questions about the charge and the possible penalty?
No, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
And do you have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
No, sir.
All right, is there anything you need to speak with your attorney about before we go any further?
No, sir.
Do you have any questions at all?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this agreement that we've just gone over?
Yes, sir.
And you do that voluntarily?
Yes, sir.
Then the charge is, as to the charge which alleges on or about February 1, 2026 in Highland County, Ohio, you did knowingly obtain, possess, or use Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code, aggravated possession of methamphetamine, a fifth-degree felony, carrying possible term of incarceration of 6 to 12 months, a fine of $2,500. How do you plead?
Guilty.
All right. Court finds on this day in open court, defendant was advised of all of his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to Criminal 11. Plea is accepted, order filed. Defendant is found guilty of the charge. He's not found guilty, but the plea of guilty is ordered to be filed. Now, the court finds that the defendant's use of drugs and or alcohol and or mental issues was a factor that led to the criminal offense in which he has entered this plea, and that intervention will not demean the seriousness of the offense and will substantially reduce the likelihood of future criminal activity. Defendant's in an appropriate certified treatment plan, the Recovery Council, according to the information that's been provided to the court. He's otherwise eligible for community control sanctions. He's not a repeat or dangerous offender and is otherwise eligible based on the stipulated questions that were assigned by the parties. So it is the court's finding that the plea of guilty be accepted, but that the case be stayed. There be no finding of guilt made at this time, and instead the defendant will be placed on community control under the conditions adopted by the court for the program under the supervision of the probation department. That will be for a period of 2 years. We're required to successfully complete the intervention plan, including that you abstain from using drugs or alcohol for a period of 1 year. And notice that you did have a positive test on July the 2nd for THC. That includes marijuana, even though we're in a state that allows marijuana use. It's the same as alcohol. We allow alcohol use also if you're over 21, but you're not allowed to use those while you're in this program. You're also required to comply with all other conditions of the probation department that the court has approved, and they'll go over with you. And you're to pay the court cost, including $50 deposit for a sealing fee if the case is dismissed. Now, in the event the defendant successfully completes the intervention plan, then the court will dismiss the case. I'll call notice of that from the probation department and set the matter for sealing hearing. If it's alleged that you have failed to comply, Mr. Crutcher, then the probation department will notify you of that, and we will have a hearing which will be represented by an attorney. And if the outcome of that hearing is you fail to comply, then at that time the court will terminate you from the intervention program, find you guilty, and then you'll be subject to being sentenced to a term of between 6 and 12 months incarceration, a fine of $2,500, or community control for a period of up to 5 years. All right. Is there anything further in counsel?
No, Your Honor.
We lost Mr.
Looks like we lost Mr. Kerr.
He says power went out.
Oh, okay. All right. Well, you are. This completes your case. You see Officer Benson. They'll transfer you to the officer for supervision on this program. The pretrial conditions, including house arrest and everything, are lifted, and you'll be under the new terms. All right. Thank you.
Yes, sir. Thank you.
All right, this is case number 21, CR 164, State of Ohio versus Wesley Howard. Present for the state is Prosecuting Attorney Collins, Assistant Prosecutor King, State's Representative Sheriff Sanders. You are Wesley Howard.
Yes, sir.
All right, and you are Counsel Alana. Is it Alana or Elena?
Alana, Your Honor.
Alana Van Gundy.
Yes,
Okay.
sir.
All right, this is a hearing on a motion filed for leave to file a motion for a new trial and to file a petition for post-conviction relief out of time. So the matter is set for a hearing this afternoon. A couple of preliminary matters. There was a motion filed for to convey the defendant, which is moot because I'd already signed an order to have him removed and brought back from the prison, and so I did not put an entry on that, but it's moot. And then there was a motion filed for the disqualification and appointment of a special prosecutor, which I reviewed and am denying on the basis that there's no ground for it. If in every case there was an allegation of misconduct by the state that would require a special prosecutor, that's all that would be done. And in this case, the court finds there's nothing at this point in the case that would even remotely support that. So that motion is denied. All right. So we're ready to proceed then on the motion. Ms. Van Gundy, you wish to present any testimony regarding this matter?
Yes, Your Honor.
All right. Do you wish to make an opening statement?
No, Your Honor. I
All
waive.
right. State.
Waive.
All right, go ahead, Ms. Van Gundy.
Yes, Your Honor. I'd like to call Mr. Howard to the stand, please.
Pardon me?
I'd like to call Mr. Howard to the stand, please.
All right. No, it's a little difficult. If you can raise your right hand slightly. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Have a seat right there. All right. And again, remember, counsel, this is a motion on whether leave is going to be granted to file the motion for new trial, not the actual new trial motion itself, although there can be some references to matters within it. But just keep that in mind. All right. You may proceed.
Thank you, Your Honor. Your Honor, would you like me to stand up or...
I'm sorry?
Would you like me to stand up or address the court from...
When you address the court stand, and as far as questioning, that's up to you.
Okay. All right. Mr. Howard, I'm going to just ask you a couple questions, okay? Can you please...
By the way, is there a motion for separation of witnesses?
Not from the state. I would prefer it, Your Honor, please.
All right. So the court will order separation of witnesses except for the state's representative, which I believe is the sheriff.
Your daughter can stay if she wants.
All right, may inquire.
Thank you, Your Honor. Could you please state your name and spell it for the record?
Wesley Howard, Wesley Howard.
Okay, and I'm just going to ask you to speak up a little bit just so that everything's audible on the please. Were you the defendant in case number 2021 CR 0164?
Yes, ma'am.
How many trials did you have in that case?
2.
And did your first trial end in a mistrial?
Yes, ma'am.
Was it around March of 2022?
Yep.
Your second trial was around August of that same year?
Yes, ma'am.
Okay, at some point did you become aware of an audio recording made by Mr. Skyler's house?
Yes, ma'am.
And did you and Mr. South get along?
Not at all.
Could you tell me what time you came, or when you came, around the time you became aware of the recording?
In between the 2 trials?
Okay, can you narrow that down at all, or you're just not quite sure?
I don't remember.
I'm sorry?
I don't remember.
Okay. Did the court prevent you from using it at trial?
Yes.
And can you explain how that happened?
My attorney didn't want to use it, and the court said they didn't want to hear it.
Okay, do you remember which hearings those were at or anything at all?
I don't.
For purposes of the record, so it's clear, that was at the sentencing portion, page 591 of the sentencing hearing, in which state offered to play it before sentencing, and I indicated I didn't want to hear it. So
That's not correct.
it's not.
I
No.
believe it was on page 598 and 599.
August 24, 2022. Let me look here.
You're going to have to go to the rest of the file.
Page 591, state prosecutor said, I'll go get it, we'll put it up on the print screen if the court's interested in seeing it.
Yeah, it's talking about Facebook messages in
It
which the
said, it also
defendant...
talked about recordings of trial prep. Okay.
It says the recordings of the trial prep as well, because I remember that conversation.
Yeah,
It was
it
about...
said, had pictures of the questions, recordings of trial prep, Mr. South recorded, and blah, 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 and gave them to Mr. Hessler, and said if the court wants to take a recess, everybody's shaking their head, no, but I'll go get it, we'll put it up on the big screen if the court's interested in seeing it, and I said I'm not. So that's the only statement the court made on the record.
Thank you. Did you know exactly what was on the recording at that time?
No, I did not.
At what point in time did you learn what was on the audio recording?
Not until it was transcribed. I seen it.
At your second trial in August, were you convicted?
Yes, ma'am.
And were you sentenced to prison?
Yes, ma'am.
Okay. Were you prevented from getting it transcribed because you were incarcerated?
Yes, ma'am.
Were you prevented from getting it transcribed due to it being expensive?
Yes, ma'am.
Do you make any money while you're incarcerated?
No.
How far did you go into school?
High school. Graduate.
You graduated high school?
Yes, ma'am.
Do you have any legal training?
No, I do not.
When you were younger, were you diagnosed with a traumatic brain injury?
Yes, ma'am.
Does that cause issues with you remembering anything?
Yes, ma'am.
Okay. So everything that, or you know you're under oath today, so you're swearing to everything that you remember accurately.
Yes, ma'am.
Did you have any sort of, once it was transcribed and you had a chance to read it, did you seek help to file your motion for a trial?
Yes, ma'am.
And where was that from?
The law library at the prison.
Okay. And you had no training or knowledge to do it yourself?
No, ma'am.
Any other reasons that you're prevented from using that recording or the transcripts?
No, ma'am.
At some point in time, did you come into possession of an affidavit signed by Mr. Scarlett yourself?
Yes.
And when did you come into possession of that?
Around February, beginning of the year.
February of what?
February
26.
Okay. I'm going to take a second and show you the affidavit.
Okay. Is that marked as an exhibit?
Yes, sir.
What is it?
That'll be exhibit A. Have you had a chance to read that?
Yes, ma'am.
And this was given to you in February 2026, you stated.
Yes, ma'am.
Is this a fair and accurate representation of the affidavit that you received?
Yes.
And did you edit or change this affidavit in any way?
Not at all.
Okay, and when did you use this affidavit when we were first presented with it?
In my motion for a new trial.
So you received it in February. Do you remember when you filed the motion for a new trial?
April.
In April. Okay, no further questions, Your Honor.
Cross?
So you were aware of the recording prior to the final trial, correct?
Yes.
And do you recall messaging Mr. Hertzler on Facebook prior to the final trial and sending copies of the questions that Mr. South had provided you with?
I do not.
You don't recall that?
No.
Objection asked and answered, Your Honor.
Can't hear you.
Objection asked and answered, Your Honor.
Overruled.
Who prepared the affidavit that you're holding?
Skyler.
He typed that?
I assume.
You don't know?
No.
And your testimony today is that you asked to bring the recording into the trial and the court ordered that not to happen?
No, I advised my attorney of it, and he didn't want to, I guess.
Have you listened to the recording?
No.
You haven't?
No.
You don't know what it contains?
No.
What do you think it contains?
I've only seen the transcripts.
So what do you think it contains that is going to get your case reversed?
I don't know.
You have no idea?
No.
So what's it matter if the recording came in or not?
Your Honor, I believe that he's established objection. He's established he has no legal training to answer that.
Overruled. Yes.
What was the question?
The question was, then what does it matter?
No more comments back there or you'll be thrown out.
What does it matter if the recording comes into evidence or not? Like, you don't even know what it contains that might help you. What are you fighting for it to come in for?
I don't know.
And you have read the transcript or you have not?
I've read the transcripts, yes.
So what is in the transcript that you think is going to get your case overturned? What's new evidence?
There's multiple things in it. I'd have to have it in front of me.
May I approach?
You may.
This is State's Exhibit to the certified copy of the transcript. I'm presenting this a State's Exhibit number 2, the certified copy of the transcript that was completed by a court reporter.
I can't even turn through it. I'm cuffed.
Well, if you've read it before and you have an idea in your head of what it contains, you tell me what you're referring to and I'll find it for you.
I don't know.
And why are you wasting the court's time with this motion?
Your Honor,
Because I know it
objection.
holds.
Overruled.
I know it holds information in it.
I'm going to push this over so everyone can hear you.
Because I know it holds information in it.
What? Just give us a synopsis, a summary, anything.
Okay. Skylar saying he has never seen me. Skylar saying he will not lie for that.
Okay.
After being asked multiple times
After being asked multiple times to lie?
after being asked the same question multiple times.
Okay.
He felt as if,
You can't talk about how you felt.
okay,
Point to the evidence.
I can't point to nothing, like I'm cuffed.
No further questions.
Your Honor, I'd like to redirect.
Yes.
Please have the exhibit. Which exhibit is this?
That's the State's Exhibit number 2.
Certified copy, State Exhibit number 2, Your Honor.
Okay.
Can you please turn to page 48?
Yep.
Can you read line number 20 out loud into the record, please?
Mr. Sal says, and I'm not going to lie for them.
Is that what you were referring to when you were talking about the evidence?
Yes.
Okay, Mr. Howard, can you also turn to page number 103 of the State's Exhibit number 2, that's certified copy?
10 what?
103, please.
See if it's even have one entry.
Yes.
Can you please read out loud to the court for the record line 22 and 23?
22. Mr. Sal said, that's why I said, like it wasn't West driving.
Were those the two comments you were referring to?
Yes.
And how do you feel that the court would believe that that would result in a new trial, or that would be new evidence, or that you were prevented from using that by not having the recording?
What was the question again?
Were you prevented from using that information at your trial by not having the recording of
Yes.
the transcript at that trial?
Yes.
How do you feel that would have changed the outcome of your trial?
Because he obviously said it wasn't me driving.
And was that used as testimony in your trial? That you were driving a car and therefore...
Yes.
Was the other comment that you read used at your trial against you?
Yes.
I know. Thank you, Mr. Howard.
I have some questions, Mr. Howard. How did you find out about the recording after the first trial?
It was sent to me.
It was sent to you by whom?
I don't remember. I guess Hertzler.
All right,
No, I
so
don't
you had it before the second trial?
Yes.
All right, thank you. You may step down. Well, wait, let me back up. Anybody want to ask any other questions as a result of what I asked Mr. Howard?
I just have one question.
All right, go ahead.
Your testimony today is that Chris Hertzler sent you that recording?
I do not remember.
That's what you said, though, correct?
I heard you say that.
No. Wasn't that the answer to the court's question? You said, I guess Hertzler sent it to me?
I guess. I don't
That's
remember.
your testimony under oath.
I do not remember.
So what's your answer?
That I do not remember. It was sent to me on Facebook. I do not remember. That's my answer.
No further questions.
Any other questions?
Yes, Your Honor. Again, did you testify to the court that you provided this to your attorney?
Yes.
And did your attorney bring it in?
No.
Did you ask your attorney to bring it in?
Yes.
Okay. Do you feel that you were prevented from using it because your attorney did not bring it in?
Yes.
Thank you. No further questions, Your Honor.
All right, you may step down. Any other witnesses? Do you have any other witnesses?
One moment, please, Your Honor.
Yeah.
I'd like to call Skylar South, Your Honor.
All right. Thank you, Mr. Rader. Have you been sworn in? Raise your right hand, please. Do you solemnly swear the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Let's see right there. All right, you may inquire.
Thank you, Your Honor. Hi, Mr. South. My name is Alana. I'm Mr. Howard's attorney. We haven't met before, so I just wanted to introduce myself. I have a couple questions for you today.
Okay.
Can you please state your name and spell it for the record?
Skylar South, SKYLER, SOUTH.
Were you at some point in time a confidential informant on the case involving Mr. Howard?
I was.
Do you know who Prosecutor Collins is?
No. Oh, you said Collins? Yes, I did.
That's yes for the record. You
Yes.
know who Ms. Collins
Yes,
is?
I did.
Did you have direct contact with Ms. Collins during that case?
Yes.
Did you have contact with her in person?
Yes.
Did you have contact with her via text message?
Via Facebook, but not.
So with instant message on text message on Facebook?
Yes.
Okay. I'm going to hand you, this is from the prosecutor's exhibit in response to with her text messages that she submitted.
Are they marked?
Not yet, Your Honor. Will be exhibit B. Can you just go through those real quick and read and make sure that
Sure.
and look at them?
Okay, yeah, I remember all these.
Excuse me?
I said, yeah, I remember all
I'm
these.
just going to ask you to speak up a little bit so nothing shows up as inaudible for me.
Okay.
You do remember them?
Yes.
Okay. Did you send, are those your messages to her and her messages to you?
Yes, the Facebook ones.
Could you please turn to page 8 of that? And Your Honor, just for the record, this is pages 1 through 18 on the state's memorandum contra defendant's motion for leave to file a motion for a new trial. I believe you have page 8 in your last search.
Exhibit A.
It's just page 8.
Okay, yeah.
It does say Exhibit A on it, but it's just page 8. On page 8 do you see it page 8 on the bottom?
Yes, I see it now.
Okay. Did you send that text message to her at the bottom?
No.
Could you read the text message to me at the bottom?
It says, before you go filing warrants, let me understand I was yanked up and scared for my life.
Can you note the date of that text message, please, right above it?
Friday, April 1st at 1:52 p.m.
And that would be after the trial, correct? This trial was March 28th.
Correct.
And you're stating that you did not send that?
Not about being held captive, no.
Okay.
None of that.
So, but the question about being yanked at the very bottom, the February 1st, and being scared, did you notify Ms. Collins that you were scared to testify?
No, I did not. I had disagreements.
Okay. So is that document altered from what you had originally sent in your messages?
I had never sent her anything on a text message that said anything about being yanked up and scared for my life.
Okay. Were you asked to testify at Mr. Howard's trial?
Yes, I was asked to testify.
And did you testify at Mr. Howard's trial?
No, I did not.
Why did you choose not to testify at Mr. Howard's
Because I felt it was wrong, because I have never really had anything to do with his case except one occurrence, and I've never seen the man in person until like now and a few other times, but it had nothing to do with the case or drugs or anything.
Okay. So it's your testimony today that you did not tell the prosecutor that you were scared of testifying.
Correct.
And you left the hotel, correct, the night before?
The morning of.
The morning of the trial?
Yes.
Okay, and why was that?
Because I didn't want to testify.
Okay. No further questions this time, Your Honor. Thank you.
Thanks.
Ross?
Mr. South, I'm now going to approach and hand you State's Exhibit 1, which are also included in the memorandum. Do you recall, we're going to talk about page 8, the one you just testified to. This is a text message. Do you recall sending this message to Chris Bowen when he was there to pick you up at the hotel?
No.
You don't remember that?
No.
So if Captain Bowen says that he does recall that, you don't remember that?
I do not.
So who do you think you were texting here?
I wasn't texting anybody. I didn't text you guys that morning at all. Nobody. The U.S. Marshals called my phone.
Right. So you don't recall on April the 1st sending that text message to Captain Bowen?
No, miss.
Did you provide the recording that you made in the office? Did you provide that to Brittany Howard or Wesley Howard?
I didn't provide it to either one of them.
Did you provide a copy of the questions to Brittany Howard or Wesley Howard?
I didn't provide it to either one of them.
How did they get that?
I have no idea.
Do you recall that you were at the hotel during the first trial with Brittany Howard?
I've seen Brittany, yes.
You don't recall that that's who you were staying at the hotel?
She wasn't staying there, no.
Do you recall telling the sheriff that that's who you were with?
I might have been with her one time, but she wasn't staying at the hotel with me.
During the time that you were supposed to be here testifying?
I was in Goshen at the trailer park, actually.
You were brought up to the jail last night, correct?
Monday, yes.
Monday, I'm sorry. You made a phone call and talked with your mom and stepdad on the phone, correct?
I spoke with my mother and stepdad, yes.
And you said, I'm going to paraphrase, but do you recall saying to your dad, after Wednesday, I won't owe anybody anything. I won't have to look over my shoulder anymore? Something to that effect?
Yes.
Who were you talking about?
I was talking about this entire court proceeding because I seen no need for me to be here, miss.
You don't see any need for you to be
I'm
here?
serving out my sentence.
Excuse me. You don't see any need for you to be here?
I mean, not not to put Mr. Howard behind bars, no.
Well, you didn't put him behind bars. You didn't even testify. You didn't show up.
That's why I don't understand why I'm here.
Oh, okay. Do you recall typing out an affidavit?
Yes, I do.
Okay, where did you type that?
It was done on a computer.
Where?
A Chromebook.
Whose?
I have a Chromebook.
Where? Where were you? When you did this?
Between Portsmouth and Courthouse.
Okay. And were you with Holly and Brittany Howard when you did it?
Not at the time, no.
But then they drove you to a notary.
They didn't
correct?
drove me. I drove myself to a notary.
With them?
They were in separate vehicles, but we met at a notary, yes.
Okay. And everything contained in that affidavit, it's your testimony is true, correct?
If it's the affidavit, yes.
Have you listened to the recording that you made and passed around?
It's been so long.
Well, in your affidavit, you state that Sheriff Sanders and Prosecutor Annika Collins wanted you to lie on the stand in Wesley Howard's trial under oath by answering all questions with the answers that they provided.
Correct.
That's your testimony and that's in your affidavit.
Yes, it is.
I'm going to provide you with a copy, a certified copy of the transcript of that recording. Can you find in there where you were told to lie?
Can I ask what recording this is?
I'm sorry?
What recording is this?
That's the original one that you made and passed around.
Oh, you mean the one that recorded everybody when we was up in the courthouse room?
Yes.
Because that has nothing, that was, no.
What do you mean, no? That's why we're here today.
Because of this?
Yes.
Oh.
Where does it say in there, where in there are you told to lie?
Well, I mean, I can't exactly move my hands to flip through this thick copy of papers.
Well, you've listened to it. It's been in existence for quite a while.
It's been a few years, Ms. Collins.
You swore to an affidavit.
I said I felt like you
Just a
wanted me
minute.
to lie, yes.
You swore in an affidavit that we told you to lie, which means you're familiar with this. So where is it in there?
I have no idea.
No
I
idea.
said,
The defense attorney pointed out something on page 48, taken out of context, but let's look at that.
okay.
Mr. King, that's who actually prepped you for trial, correct? Mr. King, I didn't question you, did I?
Yes, Mr. Adam King, yes.
Mr. Adam King,
Yeah.
not me.
Yes, correct.
Are you familiar with who drove the vehicle? Like through hearsay, yeah, but yeah, weren't you, so did you. I never physically seen him. That's you, correct?
Never physically seen him, yes, speaking about what
Okay.
Mr. Howard.
And Mr. King says, right. And you said, I'm not going to lie for them.
Correct.
Well, who asked you to lie?
It was just the way everything was written, like a yes, no, like you're going to get on stage and you're going to, or get on stand.
And tell the truth.
And say yes or no to this, And,
Okay.
Yeah,
Do you know how many times you were told to tell the truth during this recording?
I do.
You don't have any idea. What if I told you no less than 3 times you were told not to lie?
Okay.
Would you disagree with that? Mr. South, you put in your affidavit that Rebecca Davis was also told to lie. During the trial, my wife, Rebecca South, did cooperate and testify, giving the answers provided by the prosecutor. That's what you put in your affidavit. So that means you swore that out and that's the truth, correct?
Correct.
On what basis do you have to say that she gave the answers provided by the prosecutor?
On the basis is that you had given her a deal that she would get her divorce in return for doing what you wanted them to do, wanted her to do on this case.
She told you that?
Correct.
She told you that the deal was that she did what I wanted and then I would help her with a divorce?
Correct.
It wasn't that she would testify truthfully?
That's all I have to say about it.
Is that what you were told, to testify truthfully?
Yes.
You were told that by the state, correct?
Correct.
Testify truthfully.
Yes.
But you didn't show up to testify at either trial.
No.
And it's your testimony that you did not send a message to Captain Bowen that you were snatched up.
Correct.
You didn't send that message.
I did not.
So if he testifies that you did, then he's lying.
Correct.
Okay.
I remember when they came.
Mr. South, do you know, or do you understand how IP addresses and things like that work? And
Yes.
Okay. Do you recall having another Facebook conversation with me under another Facebook name and deleting those messages off?
No.
You don't remember that either?
Could you refresh me?
Do you recall messaging the Highland County Task Force and saying that part of the reason you were doing that is so you could set things straight with right? You felt bad about this recording?
I do remember messaging the Highland County Task Force, and I actually still have the current messages on my current Facebook account, and I cannot even message the Highland County Task Force anymore for some reason, but those messages, I specifically remember asking for help to get a ride back to, I believe, Sober Living, and I explained that my car had been impounded, etc., and I had asked, I think, maybe 1 or 2 times who I was speaking with. Nobody would tell me, and I was told that I had pretty much screwed you over, Ms. Collins, and that I had passed around this recording and blah, blah, blah. Well, they asked where I was. I told them where I was at. Next thing I know.
Somebody came and arrested you.
Yes.
You had a warrant.
Correct.
Okay. So, but you do remember having the conversation with the task force.
Correct.
And you say you want to speak with Steve Alexander, correct?
Yes.
And you say, whoever says something about this is the task force, and you said, I don't know who that is, and I said, you know who the task force is. You recorded the prosecutor passing it out as some great evidence. Do you remember all this?
Yes, I do remember this.
And then do you recall saying, that's what I was trying to get in contact with Steve or someone about?
That's right. They asked why would you want to speak with Steve? Yes.
You didn't pass the recording out. You wanted to make things right. You recall that?
Yes.
So that's you.
Yes.
I'm going to look at something else. Let's look at page 11 to 18. Do you recognize this?
What are you looking at?
Still states Exhibit 1, but pages 11 through 18.
Trying to remember what our messages were because I didn't.
What did you say?
I'm trying to recall what these messages were that says that they were removed because I didn't remove them.
Who did?
It says this message was removed because it doesn't follow our community standards.
Okay, so
I didn't delete them. It would say user remove message.
every single message that you sent has been removed. Can you confirm that?
Yeah, none of them are there.
Right? But you can confirm that every message you sent was removed, correct?
Yes.
So my responses, which can't be removed and for whatever reason doesn't go against community standards, they're not removed, but all of yours are. Correct?
Correct.
So it's hard to tell what you said in the middle here, but I say, what is this about? I say, were you threatened? Then there are 2 responses from you that have been deleted somehow. And you said, and I say, when and by whom? Well, wouldn't that refer to, were you threatened? When and by whom? It makes common sense, doesn't it, Mr. South?
I mean,
Yes.
I guess. I mean, I didn't remove the messages. It would say that it would specifically say a user, me, removed the messages. If anybody knows anything about Facebook Messenger.
So I'll ask you the same thing I asked Mr. Howard. What makes a difference why you did or did not testify? The bottom line is you didn't show up, correct?
Correct.
And you didn't give any testimony against this defendant, did you?
No.
And he was convicted anyway, correct?
Correct.
So who cares why you didn't show up?
I have no idea.
You had subpoenas. You knew we were supposed to be here, correct?
I mean, yes, I knew I was supposed to come.
Okay. And isn't it true that Captain Bowen came to Washington Courthouse to pick you up from the hotel that we paid for you to stay at because you were afraid?
He did pay for that, yes.
Okay. And you weren't there, were you?
No, I was not.
So you just elected not to appear,
Yes,
and it doesn't matter what your testimony was or would have been because you didn't give it.
correct. I didn't feel it was right.
Okay.
Bottom line.
So nothing that you did played a part in Mr. Howard getting convicted, correct?
I mean, the whole county of Highland County seems to think so. I've been through hell and back over this case, and I didn't even show up to convict him.
Well, maybe you put yourself in that position, Mr. South.
Thank you.
Anything else, Randy? No further questions.
Redirect.
Thank you, Your Honor. So this would be Defense Exhibit B, States Exhibit 1, I believe. Yes, 1. So the same text messages. I'm going to ask you to look at page 7 and read 7 out loud. Read this
Which page?
page 7, Your Honor.
Which exhibit?
I'm sorry?
Which exhibit?
It would be my Exhibit B, the State's Exhibit 1.
So read from here.
Just please read your response.
I said, "Whoa, I did not say someone held me captive." And in response, I said, "Hold on, I'm going to send you a picture of the text." In response, I said, IDK, I don't know where that's coming from. And then a screenshot was received.
And to refer, that was a screenshot that you said you did not set.
Correct.
And at the bottom of that screenshot, does it refer to AI?
Refer to what?
AI, the next page.
Your Honor, I'm going to object. This AI allegation has been explained. It says edit with AI as an option, not that it was edited.
I agree with that. I'm familiar with that. I'll sustain that objection. That's a red herring.
Please go ahead and read the your message here at the bottom of page 9, and this was your response to the prosecutor.
I said, "You got me all wrong. I never once said I was held captive. Like WTH, which means what the hell, and I'm only loyal to the right people, and so far that's only one person."
And what person would that be?
That would be God.
Who?
God himself.
A couple more questions for you. Was that the recording, this infamous recording, was that the only time that you met with the task force?
No.
So how many times did you meet with the task force?
For separate things.
Can you estimate how many times?
Here, I'm going to object. It's outside the scope of cross, and really, what does it have to do with anything?
It is outside the scope of cross. I'll sustain objection.
What made you feel like you had to lie?
Just the way the things was worded in the paperwork that was given to me between me and Mr. King. They're going to ask you this, you're going to say yes, or you're just going to say no to the questions, and I didn't feel like that was right. Like I would.
And when you did not show up and you refused to testify at Mr. Howard's trial, were you charged with theft by Highland County?
Yes, I was.
And are you concerned about your testimony today that you'll be charged with another crime?
It's crossed my mind. I just would like to finish my STAR sentence that I'm currently serving and move on with my life from all this.
Okay. No further questions, Your Honor.
I have some questions for you, Mr. South. I mean, this exhibit, the transcript, that's Exhibit 2?
It's Exhibit 1, Your Honor.
Exhibit 1, all right.
I'm sorry, no, you're correct. It is 2.
Okay, I thought it was. All right. You made the recording when you were meeting with the prosecutors and officers to prepare for trial, correct?
Yes.
All right. And so you answered questions on that and about all the deals that you did that were going to be testified to at trial, correct?
Yes.
And as I recall, and I sat through the trial twice, there were videos and audios of you and your wife and the various, and then they were being observed and surveyed by the officers, right?
Yes.
All right. And so you admit that you were involved in making purchases of drugs in this case, correct? And I know I'm not saying it was directly from Mr. Howard because they weren't, but you were involved, correct?
I was involved in purchasing drugs, yes.
All right. And and you were not present for trial, either trial, correct?
Correct.
All right. Now, if anybody has any questions about what I just asked, you may follow up. Do you have anything?
Yes, Your Honor.
All right, go ahead.
Mr. South, had you testified at trial, would you have testified to what was in the recording that you did not see Mr. South or Mr. Howard?
Yes.
No further questions, Your Honor.
And just for the record, I think that there was never any claim that he was seen in the car because the car had tinted windows and the officers all testified they couldn't see it. So having sat through the trial, I remember that very well. So do you have any questions you would like to ask?
No.
All right, you can step down. Any other witnesses?
No, Your Honor. Thank you.
All right. Are you resting?
Yes, Your Honor. Thank you.
All right. You wish to move admission of your exhibits?
Yes, Your Honor.
All right. Any objection?
No.
All right. The exhibits are admitted. I think it was A and B.
Yes, Your Honor. A would be Skylar's affidavit, and B is the Facebook messages between the prosecutor and Mr.
Yeah, that's
South.
actually part of
The memorandum.
State Exhibit
1.
1. Okay.
Yes, Your Honor.
All right. State have any witnesses?
The state does, Your Honor.
All right. I'm going to call the first witness.
Rebecca Davis.
Rebecca Davis.
Rebecca South.
Okay.
The court will know her as Rebecca South.
Did you get sworn in the clerk's office? Okay, if you got your right hand raised, you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Seat over there and pull that mic over in front of you, please.
Please state your name for the record.
Rebecca South.
Ask them.
You're still Rebecca South?
Yes.
Okay. And Rebecca, do you recall being a witness for the state in the case State versus Leslie Howard, Chris Hertzler?
I do.
And do you recall meeting with myself, Mr. King, at the time, Investigator Sanders, maybe some other law enforcement to prepare for trial?
I do.
And do you recall how the trial prep went? Like, can you just summarize what took place?
So we met in a room. We pretty much just listened to previous recordings. That was video, audio stuff from, the case and everything that went down. And that was pretty much it. So that way we could refresh our memories because it had been 2 years prior. That's pretty much it.
When you say the previous audio and video recordings, are you referring to the recordings of the drug transactions?
Yes.
At any time during let me back up. Once we listened to the recordings of the drug transactions, did we go through question and answer back and forth?
Yes.
And were you provided prepared questions after the meeting?
Yes.
And in the prepared questions, are there answers under the questions?
No.
Well, after we met, were there answers?
Yes.
Under the
My answers, yes.
I'm going to hand you what's previously been marked as State's Exhibit 3 for identification purposes.
Okay.
Rebecca, do you recognize that?
Yes.
What is that?
This is the case, the briefing.
Are those the questions that were asked of you during the trial?
Yes.
And were those the questions that you were given after your trial prep?
Yes.
Under the questions are words in italics. Whose answers are those? Mine or yours?
Where are they at?
Yes, the things in italics.
Those are my answers.
I'm going to flip to the back page of this 8-page long document.
Okay.
Rebecca, can you read that?
I have put the answers so you give me in italics. Please remember that it is most important to tell the truth. If you don't remember, say so. If you don't know the answer, say so. If you are confused, say so. You are doing amazing and we are really proud of you. Let me know if you need anything or if you have any questions with the numbers and the emails.
During the entire time that you prepared for trial, you actually prepared twice. you every single time you met with us?
To always be sure to tell the truth.
Rebecca, were you promised a divorce or anything like that if you cooperated with the state?
No.
So if Mr. South made those allegations, would that be untrue?
Yes.
If Mr. South swore out an affidavit that said, during the trial, my wife, Rebecca South, did cooperate and testify, giving the answers provided by the prosecution, would that be true?
No.
Who gave the answers?
I did.
No further questions.
Cross.
At all points in time, were you with Mr. South and the prosecutor and the task force?
Excuse me, can you restate that?
Were you with Mr. South every time he was with the task force?
Not every time, but
Okay, so you wouldn't be able to note whether or not what he was told.
during this certain case, I was.
You were with him at every meeting
Yes.
with the task force.
Yes.
No further questions, Your Honor.
Redirect.
I know. Ms. South, I think maybe the defense attorney doesn't understand. I know that you are confused.
Okay.
When she says every meeting, are you referring to the drug transactions?
Yes.
Okay.
Sorry.
When you met with us in our office, was Mr. South with you?
No.
When he met with us, were you with him?
No.
But during every drug transaction, were you with him?
Yes.
No further questions.
All right, you may step down. Thank you.
Chris
Next
Bell.
witness.
Huh?
Next witness.
Chris Bell, and I think they're getting you up to him, Your Honor.
Were you sworn in?
Yes.
All right.
Please state your name for the record.
Chris Bowen.
And are you currently employed?
Yes, I am.
Are you employed at the Sheriff's Office?
Yes.
And were you, during the case of the State versus Wesley Howard and Chris Burstall, were you employed with the Highland County Task Force?
Yes, I was.
We're going to go way back and talk about what happened during that trial. Do you recall the first trial being in March of 22?
Yes.
Do you recall where Mr. South was staying? Let me back up. Did the task force pay for a hotel room for him?
Yes, we did.
And why did Mr. South tell you he needed us to pay for a hotel room? Do you remember it?
I don't remember.
Do you remember going to pick him up on the morning of the trial?
Yes, I do. He wasn't there.
Do you recall sending him a text message?
Yes.
Do you
recall
remember?
that. I don't recall what the text was about, but I do recall.
But you do remember sending him text messages?
Yes.
Did Mr. South tell you why, if you recall, and I'm going to find the message, but did he tell you, or do you recall why he wasn't there for you to come and testify?
I don't recall, but if you could show me the text.
I'm going to hand you page 8 of State's Exhibit 1. That's a screenshot, but do you recognize that?
Yes.
What is that?
That's a text message between myself and Mr. South.
And what did you text to him?
I'm here at the motel. You're not in your room. Where are you at? Are you going to be in court? Let us know you're all right. And then he responded, before you go filing warrants on me, understand I was yanked up and scared for my life.
Is this a true and accurate copy of a picture that was taken of your phone?
Yes.
And do you recall this happening?
Yes, I do.
Captain Bowen, how many times, if you recall, did Skylar South express that he was afraid to testify?
None.
I'm sorry?
I never ever heard him say that.
Do you remember him talking about being held in the back seat of a car at Kroger's?
I do not.
You don't recall that part?
No.
Okay. Were you present for the trial prep involving Skylar South?
Yes.
In the prosecutor's office?
Yes.
And Captain Bowen, roughly, how many trial preps have you been involved with the prosecutor's office here for?
Oh, my goodness.
A lot.
A lot, yes.
Captain Bowen, at any point during the trial prep of Skylar South, and let me back up, were you present for the entire trial prep?
I was there for portions that I recall, but for the most of it I was, yes.
Do you recall any time that myself or then Investigator Sanders instructed Skylar South to lie?
Absolutely not.
In fact, have you listened to the recording of this trial prep?
Yes,
Do you recall Skylar being told to tell the truth?
that is what he was instructed to do.
In fact, aren't you one of the people that told him to tell the truth?
Yes.
Have you ever heard during a trial prep anybody from the prosecutor's office instruct someone to be untruthful?
Absolutely not.
What is the standard during your trial preps? What has the standard thing always been regarding testifying?
Telling the truth.
No further questions.
Ross.
Here I'm referring to the same page, number 8, 7, and 8, with the screenshot. Sir, could you read the bottom text for me, please?
Clear at the bottom?
Yes, sir.
Okay. Before you go filing warrants on me, understand I was yanked up and scared for my life.
Is that the first you had heard that from him?
Yes.
Okay, can you read the date on that?
Friday, April 1st.
Okay, so if anybody had stated that he was scared prior to that, is that correct?
Pardon?
If anybody had stated that he was scared prior to April 1st, according to your knowledge, that's incorrect.
Yes.
Thank you. No further questions.
Redirect.
I have no further questions.
May step down. Next witness.
Sheriff Sanders?
Have you been sworn in? Raise your right hand, please. You solemnly swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth shall be God. See it, please. May inquire.
Please state your name for the record.
Randy Sanders.
And are you currently employed?
I am.
Are you now the sheriff of Highland County?
I am.
Back in March and August of 22, were you working as an investigator with the Highland County Task Force?
I was.
And had you prepared an engaging threat activity case against Wesley Howard and Chris Hertzler?
Yes.
And did you use Rebecca and Skylar South as CIs in that case?
Yes, I did.
Do you recall the trial prep with Skylar South?
Oh, I do.
Were you present for the trial prep with them both times?
Yes.
And during that trial prep, let me back up. Have you listened to the recording that Skylar took of that trial prep?
I have.
And do you remember basically everything that it says?
I was just our normal trial prep with questions and you asking, going over the questions and us telling you the answer. The same thing we do every time.
At any point in that recording, was Skylar told to lie?
No, never.
And at any point in that recording, was he told to tell the truth?
Yes.
More than once?
Yes.
At any point during the trial prep with Rebecca, were you present for that as well?
I was.
Was she ever told to lie?
No, she wasn't.
Was she ever promised anything in exchange for her cooperation?
No, not during the trial prep. No.
And you recall the trials, both trials, correct?
I do.
And do you recall Skylar South testifying?
He did not.
Why not?
He didn't show up.
Had he made promises that he would be there to testify at both trials?
The first trial, yes, he did.
Do you recall the second trial, him also saying he would come testify?
I don't recall.
Do you remember Skylar, during the life of the case, indicating that he was afraid?
No, not during. I kind of thought he was afraid, but he never told me that he was afraid.
Was that when you were buying drugs or during the trials?
That was when we was buying the drugs.
During the trials, after the cases were filed and it was time to start testifying and things like that, did Skylar indicate to you that there had been threats on his life, or he felt threatened, or he didn't want to testify because he was afraid?
I don't recall. Sorry.
Does he remember that? Okay. Do you remember at any point when, after the first trial, where Skylar indicated who he indicated he was with, and that when he didn't show up for the first trial?
Yes.
Who did he tell you he was with?
And he told me he was with Brittany.
Brittany who?
Wes Howard's sister. I don't recall the last name, but I know he explained who that was. He had talked about Wesley and his family a few times.
And being in contact with Brittany and staying with her instead of coming to testify?
Yes.
No further questions.
Cross.
Thank you, Your Honor. Have you reviewed the transcript?
I have not.
Okay, but you were there that day.
Yes.
Do you recall a statement of Mr. South stating that he did not speak with Brittany? Because Brittany and Wesley did not like each other?
That who had not spoken to, that Skylar had not spoken to me?
Do you
To
remember
her?
any conversation at all surrounding the fact that Brittany, his sister, and Wesley did not get along?
Oh, yes.
Okay, so,
I don't know I didn't. We never got into the extent of it, but I knew they weren't close.
so at the prosecutor's preparation meeting, it was the prosecutor, Ms. Collins, and Ms. South, Mr. South, and how many police officers?
No, Skylar and Rebecca wasn't in the same meeting at the prosecutor's office, ever.
Okay, so the meeting that was recorded, how many officers were in the room with it?
I know I was in there, and I know Adam was in there, and Annika, and I'm not sure whether everybody else was in there all the time or not. There was two different times that we done trial preps with multiple witnesses, and I know Chris Bowen was in there part of the time, and Brian Butler was in there at one point.
Okay. And the prosecutor had stated multiple times that there was no explicit question as to asking Mr. South to lie, correct?
Oh, he was told not to lie.
He was told not to lie.
Yeah, he was told to tell the truth.
Okay.
Yes.
And when he did not testify, he was charged with theft by this county, correct?
He was.
Is it possible that he was intimidated while he was in the room and you didn't have to ask him to lie?
Objection as to what was possible and not possible.
Yeah, I'm going to overrule. I'm going to sustain your objection. Pardon me?
No further questions.
Okay. Can you redirect?
I have nothing.
Let me step down. All right, thank you. Any other witnesses?
Nothing. No further witnesses, Your Honor.
Move admission of your exhibits.
We would move to admit States Exhibits 1, 2, and 3.
What was 3?
I'm sorry, I have them right here.
Okay. This is a question. Mrs. South, that's Davis, I guess now. All right. Any objection?
No, Your Honor.
All right. State's exhibits are admitted. You have any rebuttal, Ms.? Yeah, you have any rebuttal?
I'd like a closing statement, Your Honor.
Yeah, but any rebuttal?
No, Your Honor.
Okay. All right. You may make your closing statement.
Your Honor, the standard for this trial that we have to meet is that Mr. Howard was unavoidably prevented from using this recording. From the testimony today, we know that he did not have the recording at the first trial. It came at some point in time between the first and second. He presented that to the attorney. It was not used, so he was prevented at that point in time. It was presented by Ms. Collins. The court chose not to hear it. So there were multiple times.
Wait a minute. Oh, okay. At the sentencing. All right. Go ahead. Sorry.
Yes, Your Honor.
You're right.
Respectfully, Your Honor. at the point that he got the recording, everything was speculation, and we didn't know what was on it. He was unavoidably prevented from using it as he was incarcerated. He did not have money to transcribe it. He would have no way of knowing how to use it. He had no legal training. He had to request help from the law library in order to actually write this motion. And he also did not have access to Skylar South and his affidavit until February of this year. So there was absolutely no way that he could have had this evidence at his trial. And this evidence is clearly stating that Mr. Howard was not seen, and also that Mr. South testified himself that he was not scared, and that was not the reason that he didn't show up to testify, Your Honor. So we would request that the Honor consider our exhibits and arguments and testimony. Thank you.
Ms. Collins?
Your Honor, I'm glad that the court had a hearing on this, because this whole recording thing needs to be put to bed. This has been a nuisance for the state and investigating officers since it happened. I think that this defendant, Mr. South, and half the defendants in Highland County think that they've got some golden egg with this recording. But if you listen to the recording or you read the transcript, an actual correct transcript, done by a court reporter, you'll see that not only is Skylar not told to lie, he's told to tell the truth multiple times by multiple people in the room. The trial prep with Skylar is not even with me, it's with Mr. King. So this allegation in his affidavit that the sheriff and I wanted him to answer the questions with the answers provided is nonsense. We didn't provide him with the questions or the answers. Mr. King did. Next, his allegation in this affidavit that Rebecca South cooperated because she was promised something also has been proven to be a lie. Rebecca cooperated because she had promised the task force that she would follow through, and she did so. And how the trial prep works was explained by both Captain Bone and Rebecca, and it works the same for everybody. So this recording isn't a golden egg. If you read it and you understand what you're reading, or you listen to it and you understand what it is, it's Mr. King going through questions with Detective Butler, and when they're done, he then goes through questions with Skylar. Now, there were a few times where Skylar's like, well, do you want me to say this? And the response from everyone in the room, myself included, is, you tell the truth. If you don't remember, say you don't remember. If you don't know, say you don't know. He was never told to lie. And who cares if he did? If he was, he didn't show up. So nothing that he said during the trial impacted this case whatsoever, because he didn't say anything at trial. This defendant was convicted based on the videos and the testimony of the officers and of Rebecca. Skylar really has no bearing on this. Who cares why he did or did not show up? Now, he can say now he wasn't afraid, but Captain Bowen, who has a much longer history of integrity with this court than Mr. South, testified that the screenshot of that message saying I was snatched up and unable to, whatever he says, that was his response to Captain Bowen asking, why aren't you here? Why aren't you coming to court? He knew he was going to get a warrant filed on him if he didn't show up. We had told him that. So that's exactly what he says. Don't go filing a warrant on me. I was snatched up. Well, he was snatched up by the defendant's sister. He later told Sheriff Sanders that he was with Brittany Howard. That's how they got a hold of the recording. He provided it to Brittany, who provided it to Wesley, who then gave it to Chris Hertzler in a Facebook download, because I was reading their Facebook messages during the time between the trials. We knew about this recording long before the second trial, and I'll go further and tell you that both Mr. Mormon and Mr. Wagner and Mr. Armertrout contacted disciplinary counsel to see if there was a problem with the fact that somebody had recorded our trial prep. No, there wasn't, other than it should be some kind of a crime to turn that over to the defense, I wish, and said no, and asked if I had done anything wrong or if Mr. King had done anything wrong, but all three attorneys said absolutely not. There's nothing out of line in this recording at all. So I hope that this puts this to bed. Mr. Howard needs to take responsibility for his actions. His family needs to understand that he was convicted, and that's that. There is a sentence associated with that, and here we are. Thank you.
Your Honor, I can't speak to what Ethics Council or any sort of other attorney has spoken, but I will state that I am the third attorney that has requested removal and recusal of this prosecutor. There is a reason for that. I understand that the court has dismissed the motion, but again, we stand on what we presented. He did not have the recording at the time. He was prevented from using it. Mr. South did not evince any sort of being afraid until after trial. So Mr. Howard's motion stating that it was incorrect to state that he was scared and to keep him from coming here to testify is accurate. Even if we take the edited messages or not edited, let's take the state side and say that it's not edited. The text message came April 1st. That was after his trial. So there is absolutely no, and if, again, I would renew my objection and my motion for recusal. I did call, I sent in the information for the motion for removal. I included an email in which I was told that Skylar South is being investigated by Fayette County. I contacted Fayette County this morning. There is no investigation. They do not have anything on him on file, and this is, again, another tactic of the prosecution to go after Mr. Howard. Mr. Howard deserves his time in jail.
Your Honor, has to be directed to the evidence of the case, and both of you have brought in things that are not evidence, so move on. That's not evidence about this issue, and I'm not paying attention to what she said that was not evidence either.
Fair enough, Your Honor. We stand on the testimony presented that Mr. South was not scared to come in. He did not express that, and that Mr. Howard had no access to the recording. Thank you for your time, Your Honor.
All right. Well, let me explain this. Normally, when a motion like this comes in, the court will provide a request for response from the state, and then give the defendant an opportunity to respond, particularly when there's counsel involved. But the way it was framed procedurally was it was filed as a motion for leave to file, which is actually technically correct. So, typically that's not the way these happen. So the only reason we have a hearing on this case is because procedurally, when a motion for a new trial is filed, or the newly discovered evidence under 2953, 21, and 23, the holdings of the Supreme Court in the Bethel case, and then later the Court of Appeals, which had to overrule a previous decision out of this court that they had affirmed, the Seals case, and said that you have to have a hearing on whether or not you're going to let the motion be filed. And so that's why we had this hearing. And it's clear to the court, and reviewing everything, as well as what I've heard here, that this is a much ado about nothing. It is absolutely a load of crap. Number one, the reason, and the basis is that he was prevented from using it. Well, under the Rule 33, Criminal Rule 33, B, as well as 2953, 21A2, you must file a motion for post-conviction relief within 365 days of the filing of the transcript, appellate transcript. I looked at the court's files here, and that transcript was filed on February 8, 2023. So 365 days was up on 2/8/24. Now, if there's newly discovered evidence after that date, then there is provision under the statute for leave to be granted. However, Mr. Howard testified he had the tape. It's evident that he had the tape. It sounds like there were dozens of people on Facebook had the tape, or at least what was on it. What you're complaining about is your attorney wouldn't use it. Well, good for him, because it wasn't admissible. It was nothing. Number one, hey, you be quiet. This isn't a discussion. I'm making a decision. You be quiet. Now, number one, he did not testify. Number two, there is nothing on this transcript, even looking at yours, and I haven't compared them side by side, but I read the one you submitted first, and I glanced through the second one, Exhibit 2, certified court reporter. If there are any discrepancies, I would go with the court reporter, the certified court reporter's version, since they're a professional, and it apparently was reviewed by your family and prepared by, I guess, somebody else that said typing services, and a letter from a different attorney than your current attorney. But in any event, there's nothing there that suggests any misconduct. Now, if, and again, I'm sure that's why the attorney decided not to use it. But here's the deal. You knew he didn't use it. You've said that. And your attorney says you were prevented it because your attorney wouldn't use it. Okay? Well, then you should have filed for ineffective assistance of counsel within 365 days of the February 8, 2023 deadline, because you knew about that. So this isn't newly discovered. You knew about it before the second trial, and your attorney refused to use it, and for good cause, because it was nothing. There's nothing on there that suggests in the slightest way that the state did anything improper. And all this stuff about Mr. South, number one, I don't find his testimony to be too credible, because he's been it's clear the way he handled himself and not showing up to testify, and then preparing his affidavit. Well, whoever prepared it, he signed it, and then testifying here, that they wanted him to see, or they were upset because he wouldn't say he was in a car. Nobody ever said he was in a car. The officers testified at trial that he wasn't in the car. They couldn't see through it's a Ford Taurus with tinted windows. I remember quite clearly. The reason the jury convicted him was not because Rebecca South said he was in there. She never said that. Not because Skylar South testified, because he didn't. It's because they had officers, they had surveillance tapes, they knew that was his car, and on the third count, the convicted count 6, the one where there was a pin drop and it was down a hill road, and then I believe in that case the sheriff, the investigator at the time, Sanders, actually saw the Hetzler go back to Hess. It was a circumstantial evidence case. And the reason that they wouldn't, you put in your motion, well, you should have called Skylar to testify. Well, there was nothing if he'd have testified, he'd have sunk you. I mean, he testified. We had the tape submitted in court where he's on there. He's not going to do anything to save you other than say he never saw you. Well, nobody ever said they did see you in those days. So it had nothing to do with your conviction. It was circumstantial evidence because of the work of the police officers and the sheriff's department investigators who were following him and knew his car and were able to see, knew the car, and everybody said, jury said, yep, it was him. And that's a jury question. And that issue's already been ruled on. And if Skylar testified at trial, he would have been the worst witness possible for you, because he had all these tapes where he's during the buys. He just testified here. I asked him. He admitted he made buys. He was involved with Mr. Hetzler. He didn't say he was involved with you. He never did. No one ever did. He wasn't. It was, Hetzler was a go-between. So this is a nothing. It's a big, fat nothing. And to argue that accept it. Your position is ludicrous, but I accept the fact that you adapted what he said. You were stuck with what he gave you. But it's ludicrous. This is just standard trial prep. Very thorough trial prep, by the way. And obviously the fact that Mr. South reported it would make the reasonable inference that he was already working with Mr. Howard to try to undermine the prosecution in other ways, and it didn't succeed. Because, you think you have something on it, it's nothing. The tape had nothing on it that is of any benefit whatsoever to your claims. So the court finds that your motion for leave to file, the motion for new trial and for post-conviction relief is not worthy, that this is not newly discovered evidence. In fact, it ain't even evidence. It's nothing. And the transcript isn't the evidence. You had the tape. You had the recording. The transcript is just whoever types it belief as to what was said. The evidence itself was the recording, and you yourself testified after you had it before the second trial. Your attorney wouldn't use it. And again, for good reason. I can see exactly why, because it wasn't proper. And it was skullduggery too. And, you know, it had come out that you got it from, this guy had provided it to, had recorded the conversations. I don't think that would have made a good impression on the jury. You think it would have made a bad impression on them? I think the opposite. I think it would have said, oh, this defendant's desperate. He'll do anything he can to undermine the state, including working on their witnesses and getting them not to show up and recording, because he recorded the conversation, you ended up with it. So obviously, he didn't show up for a reason. And you know, I think that it's pretty clear what that was. So even if I had granted the leave for you to file it, there's simply no legal basis nor any evidence that would allow the court to even have a hearing under 2953-21 or Criminal Rule 33. All right. So motion's denied. Remand back to custody.
Thank you, Your Honor.